Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases that we'll be hearing today. To my right and your left is Justice Eric Neyman. To my left and your right is Justice John Englander. The first 3 cases we'll be hearing are criminal matters. We will take a brief recess following the conclusion of the argument in the third of those cases and then resume the hearing session with the 3 civil cases that will follow. We are familiar with the arguments that you've made in your briefs. We're familiar with the factual and procedural history. You needn't remind us of that. We will have questions for you. Each side arguing will have 15 minutes. If there's more than one attorney arguing on either side of the V, please let us know how you'll be dividing your time, and there is no rebuttal. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains, and if you reach the end of your argument before you reach the end of your time, there's no need for you to continue speaking. With that, those preliminaries out of the way, I will call the first case, case number 2022 P 1117, the Commonwealth versus ADMILSON Rodriguez.
Good morning. Justin Cohen for ADMILSON Rodriguez. This appeal is solely of his conviction for OUI. There's a motion to suppress and various trial issues, and the evidence was essentially the same. I would like to start with the motion to suppress. Motion counsel was ineffective as shown indisputably on the record. She didn't object to hearsay, didn't get a signed affidavit from Mr. Rodriguez, and 90% of the motion to suppress was not applicable to this situation. The one thing that motion counsel got right and the motion judge got wrong was that there were statements by Mr. Rodriguez. As the police officer, the arresting officer, pushed Mr. Rodriguez against the car and asked no questions,
On what basis, let's take for a moment, I mean, reviewing the motion to suppress, other than the broad statement of all evidence, I didn't see any argument or any engagement directed towards statements. But let's, for the sake of this conversation, start with the question of whether there was a basis to suppress the statements. What is the basis? There's no question that the stop was permissible, correct?
Yes, there was an inspection sticker issue.
Okay, so on what basis? There's a fairly well-developed line of cases that say that that statements made during a routine motor vehicle stop are not subject to Miranda. So what is the basis that you suggest the statements should have been suppressed?
In Record Appendix 12, Provision 1 and 2, the motion to suppress states to suppress direct and indirect.
I understand that you are reading the motion itself broadly to encompass statements, but it's not enough to say that the motion asked for them to be suppressed. I'm asking you to explain on what basis the statements were required to be suppressed and why it was ineffective for counsel to advance argument on that basis or incorrect as a matter of law for the judge to deny the request to suppress to the extent that it was placed?
In order to answer that question, there's a case that I didn't cite, which is Commonwealth through Wilson, and it deals with what is a per se statement and what is a regular statement. And in this case, it was a regular statement because he asked the officer to take out his wallet from his back pocket. That's the statement. A per se
That statement should have been suppressed.
Yes.
And the chief is asking you, on what basis should that statement have been suppressed?
Direct and indirect evidence.
No, that is the basis on which you contend it was asked to be suppressed. I'm asking you for a legal basis that suggests that statement should have been suppressed. There is, just to repeat myself, there is a line of cases that holds that statements made during a routine motor vehicle stop are not subject to Miranda. There is no, these are statements of a party, of a defendant. There is no basis that I'm aware of that would call for the suppression of the statement that you've just described.
To take a wallet out of the person's back pocket is not a statement against interest, and the arresting officer asked no questions. So it's not an answer to a question, and it's not an issue.
What is the case that says that kind of a statement should be suppressed? Or what is the legal theory? What is the basis?
Are you arguing that he should have been Mirandized first?
I'm not arguing that.
Okay, so on what basis? I'm just struggling, and I'm sorry, but I'm missing the connection between. I understand that it is a statement. I understand that broadly read, the motion could be construed to ask for the suppression of anything, including statements. But in order to suppress something, there has to be a legal reason to do so, and I'm asking you for what that legal reason might be.
I don't have a legal reason, only that case which I didn't cite, which is Commonwealth through Wilson, which deals with what a per se statement is and what a regular statement is. That's
Well, I understand.
I'm sorry, what's the cite on Wilson, since you didn't cite it in your brief? What's the citation?
the citation on Wilson is 94 Mass. This court 416 428 a 2018 case.
Okay. Thank you.
Do you have any other issues that you want to raise with us?
Well, if this court is not convinced that to ask an officer to take out a wallet from his back pocket is not subject to suppression.
Well, let's not go that far just yet. I mean, suppose let's assume, for the sake of continuing this conversation, that that there is some basis that not yet identified to suppress the statement. Explain to us, if you could, how that statement caused prejudice that would give rise to a substantial risk of a miscarriage of justice.
It did, because otherwise the evidence was very little for OUI.
How does the request to the officer to be to remove his wallet from his back pocket bear heavily on the elements of the crime?
Only in terms of reasonableness, because the officer charged him with an expired license, but he didn't take his wallet out of his back pocket. Presumably his license would be in his wallet.
But how does the statement bear on that? I mean, either he took his wallet out or he did not, but the statement doesn't go one way or the other. I'm just trying to understand the connection between making the statement and any prejudices caused in defense at trial.
It would be prejudicial because I'll discuss the other evidence that I cannot dispute, which happened in this case.
I thought your argument was, reading your brief, that because he made statements which were not suppressed, the officer was able to testify that his speech was slurred. I didn't read you to identify specific statements that he made that were prejudicial to him in connection with the OUI defense. But I read you to say, because he made these statements, the officer was able to testify that his speech was slurred. Now, did I misread that?
That is correct.
Okay. But couldn't the officer testify to slurred speech even if he didn't testify to the substance of what your client said?
He only testified about the slurred speech based upon the statements.
But the statement, any basis to suppress statements, if it existed, would go to the content of the statements and not the manner in which they were uttered. The observation that someone is speaking in a slurred manner is a percipient observation that is independent of the content of the statement made.
The slurred speech had to do with the statement itself.
It was incidental to the statement, yes, but the suppression of the statement would not result in the suppression of the observation that that a statement was made in a slurred manner. It would be the content of the statement that would be suppressed, not the fact that it was delivered in a slurred manner.
But that was the statement, correct?
The slurred delivery was not the statement. The slurred delivery was the manner in which the statement was made, and an officer could testify to his observation of a slurred delivery without revealing anything about the content of the statement.
Well, there are certain things that happened that I cannot dispute. The first issue was that Mr. Rodriguez got out of the car before the officer got there. The music was loud in his car, so the officer instructed him to turn down the music, and he turned it down immediately. Then the officer saw, because he left the door open, he saw a Cornita bottle, which is a 7-ounce bottle, smaller than a Corona. But the officer had no idea about that at the motion to suppress.
I'm sorry to interrupt. I just have one more question, and that's about the Wilson case, which you've pointed out to us. Are you citing that for the proposition that hearsay was improperly admitted here at the motion to suppress hearing or at trial?
At the motion to suppress hearing.
Thank you.
As Mr. Rodriguez got out of the car, he had bloodshot, glassy eyes and a moderate odor, a moderate smell of alcohol. He had knives, but again, he's not like clipped to his shorts because this happened in May, so he's wearing shorts. But it's not like the Johnson case where this person was where Johnson was fishing around in his pockets to the point that the officer told him to stop fishing around in his pockets. So the knives, he's not touching the knives, he's not threatening anyone with the knives. He had the knives, but nothing with that. If the statements, like if this court is convinced that the statements at the motion to suppress would not be suppressed, then it's another issue where motion counsel was ineffective. And it's essentially the same issue at the trial. So Mr. Rodriguez asked this court to reverse the denial of the motion to suppress by the judge, and a trial probably wouldn't have been necessary if the statements had been suppressed, and it would have been pretty attenuated evidence at best. So if a trial had been necessary, Mr. Rodriguez asked this court to reverse the OUI conviction and enter judgment in his favor. I see that my time is almost up.
Yes.
If there are no further questions, I'll rest on my brief. Thank you.
Thank you.
Thank you. For the Commonwealth?
Good morning, Your Honors. If it pleases the Court, Arno Hansen for the Commonwealth, representing the Plymouth County DA's office. I would ask that you uphold this conviction. With respect to the ineffective assistance of counsel for failing to raise the motion to suppress statements claim, I don't see any inculpatory statements in this case that would incriminate the defendant. There was certainly no admission to drinking of alcohol. That being
Remind
said,
me, did he get field sobriety tests?
No. He was belligerent at the side of the road. Therefore,
Belligerent, so the evidence against him was his belligerence plus the beer and the wine in the car, and the slurred speech and the odor, right?
Correct. And he got out of the car prior to being asked, and when he got out of the car, the officer identified the look on his face.
Getting out of the car
as
without
glazed
being
over.
asked is evidence that you're driving while intoxicated?
No.
Okay.
The evidence was the second portion of my sentence, where when he got out of the car, the officer immediately noticed that he had a glazed over look on his face, which would be consistent with intoxication. So certainly on the roadside, Van Houten and Sauer both have established that Miranda isn't necessary, so there certainly wouldn't have been a legal basis.
Well, Miranda would be necessary once he was arrested, and he was arrested relatively quickly afterwards, right?
Correct, but then after he's arrested...
When he was pinned against the car, he was arrested.
Yes, he certainly was detained at that point.
There's no evidence Miranda was given, correct?
Correct, but there's also no statements admitted into evidence at the trial that would serve as the basis of his conviction. So again,
Well, there were statements. There was testimony about statements. There just wasn't any evidence one way or the other as to whether Miranda was given.
correct. But the issue again was never raised. So where the defendant fails to raise the issue, the Commonwealth is not required to then provide evidence in rebuttal of issues that are not raised. Again, the motions.
Did you find it odd when the officer testified about the arrest situation that he didn't indicate that he gave Miranda at the time of arrest?
It's possible.
Talking about the trial transcript, because that's all I've been able to read.
Right.
I found it odd. I would have thought that an officer describing what he did at the time of arrest would have testified that he gave Miranda, and he didn't.
Again, it wasn't necessarily relevant to the issue here where it was never raised. I can speak to my experience with other officers. It's often that they are Mirandized when they're back at the station, they read it off the wall. But that wasn't an evidence here because it was never really an issue.
Was there any challenge at trial to the voluntariness of the statements?
Not that I believe, no. Does the court have any other questions? For
Well, the only question I have, there was a motion to strike supplemental record appendix, I believe, and portions of your brief that rely on that supplemental material. Do you care to say anything in response to the motion to strike?
Yes, so in a subsection of the defendant's first argument, he raises that there was no probable cause to arrest the defendant, which is the basis of which would be a de Benedetto motion to dismiss, which was never filed in this case. So I made that argument in the event that that's what I had some difficulty understanding some of the arguments that the defendant made. So I raised that argument, and I felt that in order to raise that argument, the court would need to look at what was in the police report to see whether or not there was sufficient probable cause within the four corners of the police report to even support that argument, and that's why I included it. Is that? So,
Okay. All right. Thank you.
all right, thank you.
All right. The case is submitted. The second case on our list for hearing is case number 2023 P150, the Commonwealth versus Edward E. Lacey, and this case is partially impounded. I'll just remind counsel to refrain from reference to any of that impounded material.
Good morning. Are you ready?
Yes.
Yes, may it please the court, my name is Matthew Zandrowski. I'm here on behalf of Edward Lacey, and so I think at argument today I'd like to focus on the first issue in my brief.
Mr. Zandrowski, could you speak up a little bit, please?
Okay, yeah, my voice.
Thank you.
Yeah, so I'd like to focus on the first issue in my brief, the erroneous refreshing of CM's memory by the Commonwealth. I argued that it's prejudicial error where, in the middle of the cross-examination by defense counsel, during a break asked for by the witness herself, the Commonwealth showing her, or at the very least allowing her to review those cell phone records outside of court, caused a prejudicial error where her memory and truthfulness were a key part of Mr. Lacey's defense.
So, you've said it twice, prejudicial error. I'm sure you anticipated this question. How do we know there was any prejudice here? How do we know that there was any effect whatsoever on her testimony?
Right. Well, I think trial counsel did highlight this sort of at the sidebar where he did acknowledge that it would be difficult to prove the effect it would have. I think that Quincy Q sort of alludes to this, even though it came down along other lines, but where it's that risk that this might alter the testimony. And I think it also ties into my second argument that the judge could have crafted a remedy, sort of.
But how does the judge craft a remedy without knowing what he's remedying?
Well, along the lines of Woodbine, if she's testifying to a present memory of it, if she's testifying based on what she had read in the documents outside of the court. So I think that kind of came up in Woodbine where.
But what do you mean by that? Are you proposing a particular procedure to try to determine that? I'm struggling. When you say this should not have happened, I'm interested and somewhat sympathetic. But when you say the judge needed to do something about it, I'm stuck because I don't know what it is.
Right.
I don't know what happened.
Well, I think
One way that practitioners or judges commonly employ when there is such a question is to conduct a voir dire.
Right.
Was there a voir dire here?
There was no voir dire.
And was there, did defense counsel suggest that the judge hold a voir dire?
The defense counsel did not suggest that.
Okay, so what is the judge, when the defense counsel is asking for a remedy or sanctions or this, that, or the other thing, when we haven't established the underlying predicate foundation, it's a little difficult to fault the judge for not taking action when the basis for action is ill-defined, and it's a little difficult for us to evaluate or to criticize what the judge did.
Well, I think the judge had overly focused while they had their sidebar, the lengthy sidebar they had about the issue, the Commonwealth and the defense attorney and the judge. The trial judge was particularly focused on if he had prohibited the conduct. And so he seemed to be precluding defense counsel from even getting to the point of a voir dire, where his statement
If defense counsel didn't raise at any time during that colloquy or that back and forth, how is it that the judge precluded that? I understand the judge was reminding everyone that there was no order in place.
Well, I think it goes beyond reminding no order. I think he goes to the point where he feels he can't do anything because he didn't issue an order. There was no order for the witness to not review things outside of court, so therefore nothing improper happened.
That doesn't preclude defense counsel from attempting to establish, if there is a basis to establish, that something really significant that risks prejudicing the conduct of the trial took place.
Right.
But, you mentioned Quincy Q. There are it seems to me, two fairly significant differences between this setting and the setting in Quincy Q. Obviously, we have an adult rather than a child witness, and it's a jury-waived trial. And the concerns about untoward influence on the fact finder are mitigated to some extent by the fact that you've got a trial judge sitting without a jury.
Okay. Taking that in order, I think Quincy Q itself does sort of expand past the child witness. There is a footnote 17 in Quincy Q, that the SJC notes that the procedure that they're kind of recommending be done in Quincy Q with a child witness, but it's also the same procedure that's done in cases where adult witnesses can't speak English.
Well, certainly there's value in it, and that's undeniable. The question is whether its absence constitutes error that causes prejudice requiring a remedy.
Right. Well, that was just to the point of it's about a child witness.
But it is a difference, and it is a difference that bears on the rationale underlying Quincy Q. The fact that it may be best practice, even when it's not involving a child witness, is a different question, it seems to me.
I guess I would read that as stronger, where it's incorporating it past just a child witness.
There's a huge difference to me, beyond what even the Chief Justice mentions. These texts were in evidence. I don't understand exactly why the prosecutor couldn't show her what's in evidence. Even in the middle of cross-examination, even accepting the notion that under no circumstances should there be communication with somebody who's, in the middle of cross, even just accepting that, okay? If the person in the middle of cross says, hey, I'd like to look at something that's in evidence, that can happen in the courtroom. And in my experience, the judge says, sure, you can take a look at that. Or maybe not, but, what's wrong with that?
I think that it happened outside of the courtroom without anybody knowing. It wasn't a witness asking the judge to look at something. And I think especially here.
But that's the problem we started with, yeah. So you're saying, well, maybe something else happened while he showed her the text, but we don't know.
Right.
It's a little bit like that old routine where we wind up always on third base.
Had there been cross-examination? Had there been cross-examination about the texts prior to the break?
There had been a very minimal amount of reference to the text. I think the only reference came in where he had, defense counsel had asked the witness if she texted her child goodnight. And so there hadn't been any kind of, he hadn't really gotten to that point. He actually didn't really get to that point until the next day.
So they take a break on cross. The witness takes a look at the texts.
Mm-hmm.
Are you arguing that there is a per se rule that precludes a witness from looking at evidence or speaking to an attorney during a break during cross-examination? Are you making that argument? Because I'm not aware of any case or authority that says it, and I've looked, but perhaps I'm missing it.
I would probably refer back to Quincy Q, where
CQ doesn't go that far.
Right, but the idea that the prosecutor outside of court could be suggesting.
Quincy Q is direct, right? It's not cross. Prosecutor's putting his own witness on.
Well, I think that kind of makes it worse to some extent if it was direct, because I think it would have been defense counsel's prerogative to refresh that witness's memory or not. And so the DA sort of stepping into the role there or doing that when
It cannot possibly be the rule. I say this, and of course I could be wrong, but I can tell you, when you have somebody on the stand for multiple days, most trial lawyers think they can talk to that person on direct, once they've started to put their direct examination on. In fact, it's not uncommon for at the end of the day, you put somebody on for, you get their background in, and then there's a break, and then you go the next day and you say, okay, now let's talk about what you're going to say. Here's the direct examination. That can't be a rule.
So in this question, they're talking before the direct examination?
No, in the middle. You start your direct, the day ends. 4 o'clock, boom, we're done.
Right.
You're saying you can't talk to that person? You may not have even completed going through it. Maybe you got to that person earlier than you were expecting. I mean, these are all things that happen in trial. Quincy Q is a unique circumstance. The court was concerned that the prosecutor was coaching the witness to say something the witness would not otherwise say. Isn't that what that case is about?
Roughly, yeah, I think.
Okay. There is a concern when somebody's in the middle of cross that you don't talk to that person to coach them. But we don't know that that happened.
Right. I think that's where the trial judge had the duty after the objection to take some steps to inquire as to what happened.
Well, the trial judge, and I'm at volume 9, page 186, says to defense counsel, if you think there's truly something that was improper, that prejudices your client's right to a fair trial, then why don't you spell it out for me, including if you want to take a break to do that? And defense counsel responds, I don't think I need to take a break. I just wanted to preserve my objection in the case to make me cover myself.
Right.
Defense counsel didn't ask for a voir dire. He didn't make a proffer. He didn't move to strike any testimony. He didn't ask for any remedy. The judge opened it up and said, what do you want me to do? And the attorney said, I'm just making an objection, Judge.
I think maybe that might go to the point where he hadn't asked any questions about those text messages yet, and so that hadn't been developed, and so.
Did he come back later after he asked about the text and said, Judge, in light of the evidence that just came out, I moved to strike the earlier testimony?
He did not.
Did he ask for any remedy whatsoever?
He did not know. The discussion ends at that sidebar.
And he made no attempt to develop with any clarity exactly what the contours of the out-of-court encounter comprise.
Well, I think that he had the witness saying that the DA had showed him text messages. And so I think that's pretty firm.
I thought that there's some ambiguity around whether the prosecutor was involved.
Right.
Certainly the description, as broad as it is, does not negate the possibility that the prosecutor was involved, but the principal activity described by the witness seems to be between the witness and the police officers.
I think that's respectful, I think that's what the DA is characterizing it as, between the witness and the
But she
the police
testifies
officer.
that she talked to the prosecutor.
Yeah,
That's her testimony on the stand.
She is pretty direct that the prosecutor showed her the message.
Okay.
Can we move to another issue?
I have more questions on this issue, I'm sorry. Is it improper for a police officer during a break-in examination to go back and read his or her police report?
I think that it might be, if that is impacting what his present recollection is. I think that this circumstance was sort of unique because we discovered from the witness what had happened.
Is it improper for an expert witness during a break-in testimony to go back and review his or her comprehensive report after being cross-examined in part about the contents of it?
In that circumstance, I might feel no, because that's something that expert witness would be a different kind of category than.
Why?
I
I mean, those two hypotheticals are excellent hypotheticals, right? I mean, let's take the police report one. I mean, it seems to me that probably happens a lot.
Right.
What Judge Neyman just asked you about. We're gonna adopt a rule that's per se improper to the point where a trial has to be redone?
I think that if it comes to light and then, we can determine that it's a prejudicial error, that this impacted their testimony at trial.
If it's prejudicial error, that's grounds for reversal, but you've embedded two concepts in there that aren't self-executing, prejudice and error.
Right.
So let's start with error. What makes it error?
I would point to the Quincy Q. I think my answer was focused on the prejudicial part. If, we can show that this reviewing whatever document it is.
Lots of things are prejudicial that aren't error.
Sure. I would point to Quincy Q for the error. Sort of the process of reviewing documents outside of court. I guess the contrast here is that there's another party involved. So an officer or the expert there is they're not having that outside influence that happened here, that there's the DA involved here. And so I guess that's where we might get away from that hypothetical.
But it would be
a little
different
bit.
if the prosecutor says, hey, I think you need to take a look at your report. I'm sorry, I have a question, which is, with respect to your third argument, which the Commonwealth did not respond to, I've done this before. Your argument with respect to this is prejudicial error to have allowed that statement to come in?
Yeah,
There was no objection at the time, and no motion to strike, right?
I believe he had objected to that in the
Motion to
motion
eliminate?
limine at the beginning of trial, that was.
And the judge had denied it and allowed the evidence to come in?
I believe so.
The judge deferred ruling, I think.
Oh,
There was the objection was renewed at trial.
Okay.
The objection was renewed at trial.
So why isn't that statement relevant to a modus operandi or to the state of mind of the defendant?
I think just that it's more prejudicial than probative. I think that it does have
It's a
some
403
relevance.
argument? Your argument is a 403 argument?
Yeah, exactly.
Not that it's irrelevant or that it would be necessarily excludable, but that under the circumstances, it was more prejudicial than probative and should
Yes,
have been excluded.
exactly.
Okay, thank you.
Thank you.
Good morning, may it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the defendant's conviction. And if it's okay with this panel, I'd like to briefly address the third argument that we were just discussing. I do have to apologize. In the Commonwealth's initial draft of the brief, there was an argument responding to the defendant's third argument. Somewhere along the lines of editing, it got deleted and not noticed, so that is my apologies on that. If I could briefly discuss what the Commonwealth's argument would have been to that claim, it would be...
You're going to tell us is what the Commonwealth's argument is to that claim.
Right. The Commonwealth's argument is to that claim that it was a statement directly made by the defendant to the complaining witness, and the judge, he found that it was admissible and it could be offered, and it would be up to him to determine the probative value and the weight of it.
Is your opponent correct that this was a preserved error?
It was preserved, yes. During the motion in limine, when the judge said that he was going to find it to be admissible, I believe defense trial counsel did object. And then when the statement was made again, he said, I know you already ruled on this, but I'd like to preserve my objection.
And to what probative effect?
Sorry?
To what probative effect? What was the statement designed to establish, that he was a bad person?
I think the complaining witness made the statement to show that she felt threatened, she felt she was in fear. The defendant said, you know, I just did this to someone else. And again, I think ultimately it comes back to the fact that it was a statement by a party opponent. It was his direct statement. He was there. And so I think that's
So why is her fear relevant to the crime?
I think in terms of she was being asked whether she felt that she could leave the motel room, and she said that no, she didn't feel like she could because he said...
Who asked her whether she felt that she could leave?
I believe it was on direct, yes.
So she's explaining her state of mind, and it goes to her consent and her...
Correct, and she said this, he had just told me this.
Was part of the defense that the sex was consensual?
Part of the defense was, yes.
Okay.
Well, it was also, the crime as charged was aggravated rape. The conviction was of the lesser included of rape without the aggravation factor, but threats or intimidation would be a part of the element of the aggravating factor, correct?
Yes, I believe it can be.
Oh, okay. All right.
Moving to the defendant's first argument regarding the text messages, as discussed, there was no order or directive precluding the victim from reviewing that evidence, and the defendant does not claim, and the record does not suggest that her doing so on her own initiative violated any rules or order of the court.
So do you agree that the judge could have ordered,
I agree
either through request of defense counsel or request of the prosecutor, or even sua sponte, the judge could have said, no speaking to the witness during the break?
I believe that he could have had on his own volition, he could have done that if he was asked by defense counsel or by the prosecutor, he could have. But as previously discussed, he was not asked. So when it came down to defense counsel raising the issue, and again, as we've discussed, he couldn't articulate what the error was, just that he thought it was unusual, and the judge found that he didn't find any impropriety that he could have corrected.
Don't you agree that it is unusual?
Not necessarily in the same way we were discussing that an officer or an expert witness would be able to review their material during a break.
In the middle of cross?
I guess if you just look at it like that, okay, that is it could be seemed unusual, but it was the text messages that were already admitted into evidence. I know there was some inconsistency where the victim testified that she asked the ADA to review the text messages. It's my understanding that she asked the detective to review the text messages, and then she went on a walk by herself. The prosecutor did not speak to her during that break.
Okay, that's your representation. That is inconsistent with the record. I understand why you're saying it, but that's not the record we have in front of us. The record we have in front of us is she said the prosecutor did it.
So even if that is the case, that the prosecutor handed her the messages, it is, again, they were already...
Don't we have to assume that is the case?
Sure. So if the prosecutor hands her the text messages, she reviews them on her own. Again, they were already in evidence. There was no order precluding her from doing that. So
They were in evidence, but they were also text messages between this witness, the victim in the case, and the defendant, correct?
Yes.
And that had been established at trial, correct?
Yes.
Would this be a different case if these were text messages between two other parties? She wasn't one of the parties and they asked her to review them.
I'm unsure. I could see how there would be a difference where it wasn't her direct statements that were made via text. But I think in this case where it was her own text messages and she had the opportunity to review them, it would be different. Yeah. Are there any other questions regarding the text messages?
Well, I'm along the lines of what Judge Neyman's been asking you. I'm interested in the Commonwealth's view as to whether it's appropriate to talk to a witness while they're on a break in cross-examination.
I think if we look at the Quincy Q case that was discussed, clearly there was an impropriety there where there were all those factors, where it was a child who couldn't read. The judge explicitly said, you know, she can't refresh her memory on the stand as is typical procedure. That definitely seems like the concern of there being some sort of coaching or discussions off the bench.
Yeah, I mean, Quincy Q is so this judge Quincy Q is very different than this case. Quincy Q is a case where the court said, okay, you can do it that way, and it was actually raised to the judge how to do it because it was an unusual circumstance. Here, nobody talked to the judge in advance. Nobody talked to anybody in advance. They just went off and talked to somebody in the middle of cross-examination, which I have to tell you, I've sat through a few trials in my time. Judge usually says, going back to when I was clerking, can't talk to the witness on cross.
So again, in this case, there was no order made precluding that, and I don't think there was any testimony that she was spoken to by the ADA, the detectives, the police officers. It was just that she asked to review the text. Might have been any.
I didn't ask about could. I know he could have done that. Should the judge have done that?
Where the defense wasn't able to articulate what the error was or what the prejudice the defendant had directly.
Well, no one knew. I mean, isn't it the point? Isn't the purpose of conducting a voir dire to find out what happened so that we can then explore whether there is need for remedial action?
Where there was some confusion and uncertainty about what could have happened, the judge, I guess he could, well, I keep saying he could have. I can see how he should have maybe taken that on his own, but I don't think there was any error in him not choosing to do so.
Well, we're left here with a bit of a mystery, and it makes it hard to assess whether the trial at the end of the day was fair.
Well, I think in this case, even if the messages shouldn't have been seen, even if there should have been a voir dire conducted regarding what happened out during the break, any error, in the Commonwealth's opinion, could not have been prejudicial where the messages, they had been admitted at trial for the judge to review. And the evidence he heard, apart from, even take away the text messages, take away the complaining witness's testimony, the evidence was overwhelming that the defendant was guilty of the crimes that were charged with. So there was the judge who was sitting as fact finder, observing the physical injuries of the complaining witness on the stand. He saw her medical records. He heard from 3 out of the 5 police officers who responded on the scene, and they witnessed the victim in shock, traumatized, physically injured. They heard from the defendant's family friend, Claretta Mills, who saw the Facebook post, and she called him immediately. They saw the Facebook post. They heard the 911 call where the defendant admitted to physically and sexually assaulting a woman. So even looking past the text messages and the complaining witnesses, argued inconsistencies, the evidence was overwhelming that there was no prejudicial error in this case. Are there any other questions? No?
None.
The Commonwealth would rest.
Thank you both. That brings us to the third of our criminal matters this morning, case number 2023 P64, the Commonwealth versus David A. Pagan, Jr. And just as a reminder, we will take a brief recess following the conclusion of the argument in this case.
Good morning, Mr. Chief Justice, members of the panel. For the record, my name is Attorney Edward Gauthier, and I represent David A. Pagan, Jr., the defendant.
This is not a SORB case.
Yes, Your Honor. May it please the court. Your Honor, the facts and the law in this case are well settled, and they're by agreement between the parties. Hallinan controls entirely. My client is entitled to a conclusive presumption of egregious government misconduct. The sole issue is whether he established a reasonable probability that he would not have pled guilty had he known that
So
the breath test...
let me ask you a question.
Yes, Your Honor.
It's nice to see you, counsel. The judge here seemed to apply, at least in a fundamental way, the Hallinan type of framework in his analysis in the denial of the motion to withdraw the plea. What are you saying, and I'm asking you to tell us with great specificity, what did he miss? What from Hallinan did he not apply here such that we can't give him deference we normally would?
So the question is reasonable probability. And do we look at reasonable probability from an objective, reasonable person like you or me, or do we look at it from a position of the defendant? In this case, while you and I may agree that the evidence was one way or that the effect of a plea is one way, in this case, by way of his affidavit, he established that by pleading to this OUI case, his life was turned upside down. So one of the factors, essentially,
by virtue of the conviction.
Yes.
But if he's getting a reasonably favorable disposition, and he's facing an almost certainty of conviction by going to trial, this is a slightly different paradigm, but we see these cases all the time in the immigration context.
Yes, Your Honor, I agree. I was going to draw a parallel with the immigration cases because one of the prongs in the immigration cases is fairly subjective. What would be the impact of the plea on this particular defendant, not an objectively ordinary defendant? In this case, number one, we don't concede that the evidence was overwhelming the way the judge does. We believe, number one, the hallmarks of an OUI case are erratic operation of a motor vehicle, and I'm sure the Commonwealth will argue that there was substantial evidence that my client drove his car very, very badly. However, I would point out that the police came to the scene because my client called them, because he claimed that he was run off the road by another driver. In his affidavit supporting his Rule 30, he affirms, I was run off the road by another driver, and the police came at his request. The Commonwealth would ask you to make an inference that that's evidence of erratic operation and therefore evidence of impairment. However, we don't see it that way. Also, there were no field sobriety tests, and the plea judge, and who was the motion judge, put a lot of stock in my client's erratic and odd behavior. And yes, it is fair that perhaps you can draw an inference that that erratic or bizarre behavior was the result of impairment, but we would argue that it is equally likely that it is a result of, number one, the stress of having been nearly run off the road, combined with perhaps a touch of stress and mental illness. So those facts, his erratic behavior and his having to call the police, are mixed in terms of the...
But not combined with the strong odor of alcohol, the fact that it's a single car accident.
Well, he does not...
The fact that your client... Well, go ahead.
Our position is that while it was a single car accident in the sense that there was only one car when the officer arrived, our position and Mr. Pagan's position since his arrest in this case was that although there was no collision, another car coming from the opposite direction.
I understand the point. Taking everything at face value with respect to the problem that brings us here, it is just one of two prongs on which you can prove OUI. And the reason I'm pointing that out is you can excise completely the evidence of the breathalyzer and still have an OUI case that we see, a lot here, right? An OUI case based on the evidence that the person is intoxicated by alcohol. And the two really aren't interrelated, right?
Well, the law says that you can establish impairment, or the breath test result not only is prima facie evidence of a .08 or higher, but it also is substantial evidence of impairment. It can be used to establish as part of the totality of the evidence that
right, but it's not an essential element of proof. There are ways, and we commonly see them, to prove impairment without blood alcohol readings.
That is absolutely true. There are two ways, and Mr. Pagan was charged under both theories.
So we just excise, for purposes of doing a Hallinan analysis, we're just going to excise the breathalyzer. And we're going to ask the question, how strong is the case, right?
Correct.
And what kind of a deal did your client get? Right?
I'll tell you, Your Honor, I've handled upwards of 50 of these in the trial court, and I have a bunch coming on appeal. Every single case is exactly the same. It's how bad are the facts and what was the deal the defendant got. And honestly, there's really nothing else that goes beyond.
Right.
Except
but this is the whole Hill-Strickland, the question of whether it's rational in the circumstances for the party to take the plea or whether they would have insisted on going to trial. And in that calculus, we look at the disposition, we look at the strength of the evidence. Here, let's set aside for a moment. Let's accept that the defendant's claimed perception of another vehicle wasn't a product of his impairment, and was in fact a valid perception, uncorroborated by any other evidence. But let's assume that he was run off the road. When the officers arrive, his behavior is erratic to the point of belligerence. I don't fault the officers for not conducting field sobriety tests because it would have been a fairly tense encounter. He reeked of alcohol. That's a pretty strong case.
Well, as cases go on the continuum from the weakest cases to the strongest cases, it's neither the weakest nor the strongest. I would admit, and we say, yes, there is evidence. But
let's not take the weakest to the strongest. Let's talk about cases that result in a conviction.
Yes.
This strikes me as being among that class of cases that fits comfortably within the range of virtually certain conviction.
Well, I would disagree, Your Honor. There are cases where there's an accident, there's observed erratic operation of the vehicle, there's failed field sobriety tests, there's conduct on video, either through a cruiser cam or a body
No, I
cam.
understand. I understand that there are cases that have many, many more elements of evidence.
Well,
But the question is, what are the cases that result in an acquittal that are comparable in terms of the condition, the observed condition and behavior and circumstances of the operator?
Your Honor, the acquittals never make it to this court.
I understand. I'm not asking you for citation.
So,
But this is among those cases that I think is plainly more likely than not to result in a conviction.
so let's say we take for the sake of argument that plainly more likely than not would result in a conviction. How does that factor into the reasonable probability that this particular defendant would not have taken this plea? Perhaps, let's say counsel sat down and said,
the plea is he's going to lose his license for 45 days and he's going to walk, right?
well, if we look,
That's what he got.
that's what he got, yes.
And there was incredible, in my experience, evidence. By the way, was it audio taped of him threatening the officer and his children while in the car on the way to the police station?
That's overwhelming evidence of threat to commit a crime for which he pled guilty.
What happens to that? He walks.
He pled guilty to threat to commit a crime and resisting arrest.
And he walks.
He received
He
probation.
gets no jail time.
He was revoked and he got 60 days.
Right, but that was much later. That's when he did something else he shouldn't have done. We just want to talk about what he did that day.
Right.
That evidence is going to come in his OUI case, right? In his OUI case, the jury is going to hear he threatened the officer and his children on the way to the police station.
That seems to be competent evidence. That would come in
Okay.
a trial, yes.
All right. So isn't that also a fact that we need to take in the calculus of whether or not there's a reasonable probability the defendant would not have pled guilty?
That is definitely a fact the court may consider in its calculus regarding the strength of the Commonwealth's case. Yes, that's one of the two prongs.
Well, not just the strength of the case, but also the factors bearing on the decision facing the defendant.
Well, I would agree that by being charged with crimes other than OUI, he did potentially face a more significant penalty.
And crimes about which the evidence was, let's say, less ambiguous.
If it wasn't recorded, perhaps it's ambiguous, but if it was, it is less ambiguous.
Was it recorded?
Not to my knowledge, no. But it is typically in the cruiser there may not be recording. At the police station there generally is. But at the plea colloquy,
Remember the evidence here. Did he continue his
Tirade?
verbal comments when he got to the station itself?
his conduct at the police station is regrettable, Your Honor.
During booking, the defendant made
It
several
persisted.
graphic and detailed threats against the officer.
Yes.
It goes beyond that, but let's, to get back to the issue, I
That's
just
a
want
tough case
to, I just
to
want
defend.
to understand are you arguing that Hallinan changed the playing field here, or are you arguing that even without Hallinan, the judge just simply got it wrong?
All Hallinan really did was establish that those who took the breath test on this device between 2011 and 2019 are entitled to
Meet prong one. They get the conclusive presumption.
Prong two of Hallinan essentially just applies Clark, Ferreira, Scott. It doesn't really add anything to the calculus.
I had trouble reading Hallinan, figuring one thing out. What did the judge below in Hallinan do? Did he grant the motion for new trial or deny it?
He denied it, Your Honor, and then the SJC...
But he said a bunch of things that suggested he should have granted it. Because the judge, the SJC keeps saying, well, we agree with the judge below. That was bizarre.
I have a theory, Your Honor, but it's probably wrong, that maybe the judge denied it to guarantee that it would be appealed, so that it would reach the SJC, because the Commonwealth doesn't always appeal things like that. But I would agree, the trial court seemed to be on the path to allow the motion, but then denied it, and then the SJC changed course.
I'm glad that you read it the same way I do, counsel, because when I was reading it, I was like, I don't get this. All right.
The 5 factors, Ferreira Scott, are spelled out in the brief. I don't think it is worthy of the court's time to go through each one. It's in the brief. If the panel has any further specific questions about the facts of the case, the law is very well settled. The defendant would rest on his brief.
Seeing none, thank you.
Thank you.
Good morning. May it please the court. Travis Lynch, Assistant District Attorney, Hampton District for the Commonwealth. I think we all agree it's just Ferreira Scott applied in the OUI context. The only question is prejudice. There's no prejudice. Admittedly, the judge raised his decision in terms of the newly discovered evidence test. I think that's a product of the fact that it was decided before Hallinan, so it wasn't exactly clear at the time what or how to articulate the prejudice prong, but the judge considered exactly the same sorts of factors that the SJC articulated.
So your argument is we don't have to send it back despite Hallinan?
No, because...
What's the difference?
The judge considered the exact same factors that the, it's basically impairment and whether he got a favorable plea disposition. It's the same thing. And also the defendant articulated...
I get that. I get that the framework might be similar. But what's the difference between the facts of Hallinan in this case that allows us to say, nah, this doesn't have to go back in light of Hallinan? The judge didn't have Hallinan, right?
The judge, you're right. He didn't have Hallinan. But the only thing, Hallinan doesn't change anything for this case because Hallinan is really a case about first prong. The defendant...
But Hallinan, your brother and I just talked about this. Hallinan applies the second prong.
Correct.
To a situation where the judge, where the judge denied relief, and it reverses. So the reverse on the denial of relief is essentially what? As a matter of law? Help me with that.
So,
on what basis, what standard did the SJC apply in Hallinan and decide, you know what? Relief had to be granted here.
The SJC applied the abuse of discretion error of law standard. The standard of review. That's a lot of standards.
They found that the judge abused his discretion?
Well, they disagreed with his finding on first prong. That's the difference.
No, but in order to grant relief, they also needed to find that the second prong was satisfied.
The judge as I read Hallinan, the judge hypothetically found that if the defendant had first prong, the defendant also had second prong. That's what happened there. So
why was second prong satisfied under the facts in Hallinan and not here?
Because the defendant in Hallinan did not receive a significant charge concession, or the motion judge was of the opinion that the disposition that she received.
So you read Hallinan, and this is interesting. Okay, this may help me, who's apparently unable to read this case very well. The way you read Hallinan is the judge below said, I don't think that I have to apply. I don't think I have to assume that there was egregious government conduct here. But if there was, then I would have granted relief.
Yes. Because
I'll go back and read it in that light.
That was my understanding because as I read the SJC's opinion, they agreed with, I think it was Justice Brennan when he was still in the district court. They agreed with his view that the plea deal wasn't so good, and also that the impairment evidence wasn't so
They
strong.
said that, and then
Right,
they
right.
said, and we reverse his denial.
Right, but that's because they found that the defendant got benefit of first prong. Because the whole point of Hallinan is you don't have to individually prove in each case that your breath test was actually impacted by the OT
So
situation.
on that reading of Hallinan, they haven't ruled as a matter of law that the second prong is satisfied. They've simply agreed with what they read the district court judge to have found.
Right.
Okay.
So in all these cases now, as a practical matter, we're only litigating second prong. And outside the record, but I'll just say, at least in my district, as a practical matter, we've only been opposing these motions where we had a second prong argument, where there's impairment and, strong evidence of impairment and a plea deal. So as a practical matter, I think I opposed one of these motions. Again, it's outside the record, but I've opposed one of these motions on first prong and I lost. We stopped doing that. We've only been defending these on second prong. So again, the judge didn't use the magic words drawn from, say, Clark or Scott, but that's in part because the motion below was framed both in terms of a common law newly discovered evidence claim and as a...
So let me go back to the question I asked before, just so I have it in mind.
Sure.
How would you distinguish the facts of Hallinan from the facts of this case so that we should be comfortable with the judge's exercise of discretion on the second prong?
So the first distinction that I would make is sort of a standard of review question. Motion judge in Hallinan was not the plea judge. Motion judge in this case is the plea judge. So right off the top, there's more discretion granted to the plea judge. So that's a factor. But on the specific facts of this case, you have a car accident, you have the bizarre and belligerent behavior. I'm not going to go through it. There's no need to do that. And then also the defendant, Hallinan was a single count OUI, I believe it was OUI second. The disposition was illegal, but the judge, in his discretion, thought that the disposition in Hallinan was not of a substantial enough benefit to justify not allowing her to withdraw.
Hallinan is the roadblock case, right?
Correct. So that, essentially all there was, as I recall, is there's some observations of, there's field sobriety tests and there's odor of alcohol and slurred speech, but there's not a car accident. She doesn't attack the police, that sort of thing. So here you have...
There were field sobriety tests.
You're correct.
That she failed miserably, as I recall.
Right.
Words to that effect.
Right. Well, the judge, in his discretion, that judge seemed to believe that that wasn't good enough. Again, this is sort of a product of the abuse of discretion standard. But the judge here, in his discretion, thought all this evidence is really quite powerful on an impairment theory. And again, I think it's really important that the Commonwealth made significant charge concessions here.
Help me with, I'm sure that Judge Neyman and Judge Green know this better than me, but help me with what the charge concessions are. So what is this person facing that they did not get?
So the negligent operation charge was dropped, which has a license suspension component. It's a 2-year misdemeanor maximum. It has a 2-week minimum sentence. The disorderly, admittedly, is only a 100...
License suspension component.
Right.
What is it?
I believe it's 60 days.
Mandatory 60? This
Right.
person got 45.
On the 24D disposition for the OUI.
Okay. What else?
Well, the disorderly is only a $150 fine, but still, it's a fine-only misdemeanor. The other, I think the most significant charge that the Commonwealth dropped was the assault and battery on a police officer, which is a 2.5-year misdemeanor with a 90-day minimum sentence. So if he got a jail sentence...
Mandatory minimum on the ABO police?
No, respectfully, it's a minimum sentence. It's not a mandatory minimum sentence. So if you got a sentence, it has to be at least 90.
If you decide to incarcerate, it's a minimum 90.
Right, but if you choose to incarcerate, it has to be at least 90 days. But it was a null pros, so there's no possibility of getting that 90-day sentence, even if, say, like this defendant did, you got a violation of probation.
Statements made to the police officer, they may not even be a crime, right? The statements, the threats. That's a different, well, actually, that is a crime, right?
That's a crime.
What's the crime? Threats? The threats to the police officer and his
commit a
children?
crime.
Yes, he pled, he got a continuance without finding on the OUI.
What was he,
6-month maximum?
Yeah, threats is a 6-month maximum. Resisting arrest is a 2.5-year misdemeanor.
okay.
So we dropped a 2-year misdemeanor of $150 fine and a 2.5-year misdemeanor with a 90-day minimum sentence. That's a significant amount of exposure that the defendant avoided by engaging this plea disposition. So it's fundamentally different from Hallinan.
And those are all crimes, the facts supporting of which are independent of any evidence of intoxication.
Exactly. I don't believe there's any articulated defense to any of that in the record.
Well, that's a good segue to my next question, which is, you argue in your brief that a defendant who advances a Hallinan claim in a case in which he or she pled guilty to charges in addition to drunk driving should not be relieved of proving the first prong of a Scott Ferrara claim as to the non-drunk driving counts.
Right.
Let me tell you why I'm struggling with that. It's very context-specific, it seems to me. In some cases, the evidence of the OUI is so strong, and the other counts perhaps are de minimis, or they're just other motor vehicle counts, and that sort of makes sense. But in a case like this, where it seems to me that the plea decision, the OUI versus the other counts, I don't know how we separate them. They seem inextricably intertwined. So can you address that for me? And do you understand my concern? I don't know if I articulated it well.
I understand what you're saying, but I'm basing this argument based upon the fact that Hallinan creates a presumption as to the breathalyzer. That's the argument. There's nothing, it's not contemplated in Hallinan that it would apply to any other charge. The whole point is that the breathalyzer is out because of egregious government misconduct. There's no connection, there's no other government misconduct that's been alleged or proven in this case. There's nothing about the police officers, for example.
But as a practical matter, why should we view Hallinan that way? Because pleas are interrelated, right?
Yes.
And you need to understand the whole package.
Right.
And if instead of pleading to OUI, the defendant thinks, I can try OUI, maybe they don't plead to these other offenses.
It doesn't allow the defendant to really make a rational decision, right? I mean, more often than not, they're simply going to say, yeah, but I still have these other charges, so what am I going to do? I mean, go trial back to back, I suppose, or...
Right, but the defendant doesn't have first prong as to those other charges by their nature. That's the point of my argument. I don't think...
The point of the case law is that there was egregious government misconduct that led to evidence that was before the defendant when they made their plea decision that should not have been there. All right? Now, the question is, what was the effect of that egregious government misconduct? What you're saying is the effect of that egregious government misconduct with respect to the plea should only have an impact on the OUI plea. But is that practically correct? It sounds to me like it may not be.
Because it ignores the impact that it had on the overall decision to plea, right?
But the fact remains that the defendant only has first prong as to a charge in which there's a breathalyzer. That's my point. I
understand the point, but the question when we're trying to evaluate what a rational person in the defendant's position would choose to do regarding the question of trial or plea, that is a question of the total package, right?
Yes.
Okay.
Given the overwhelming...
When we take one element out of the total package, one charge out of the total package, that bears on the defendant's mindset in making that decision.
It may, but on these specific facts, there's also nothing that would suggest that he had a defense as to these other charges.
On Hallinan, there were no other charges, right?
Right.
You just said under these specific facts of this case, right?
Right.
Right. But you're asking us...
I can see that
You're asking us to make a rule that applies
Sure.
to all cases. Big danger in that.
The court
it seems to
probably
me.
doesn't need to do that in this specific case. So, And again, this is partly because the motion is not really clear as to what charges he wanted to withdraw his plea on. So I believe there was a different attorney in the motion than on appeal.
Oh, that's interesting. So the motion itself,
As I read it, it wasn't really clear, but that was the issue doesn't need to be
don't worry
reached.
about your light, because this is an interesting little problem. Okay, so the motion itself is unclear as to whether he wants to withdraw his plea with respect to other, but it's only a withdrawal of his plea as, if he withdraws his guilty pleas, which are to, I think, 3 different offenses, do the other offenses pop back up and become, they do, right?
The ones that we know,
He would be at risk on the null pros or no?
That's an interesting question.
Yeah, that's where I was headed.
I'm not sure. And the court probably doesn't need to reach that on these facts given.
I understand that point, but,
Sure.
but it's,
And I respectfully don't know the answer to that question. I hadn't.
if the government's null pros them, can they come back? That would be quite a
disposition?
trick, yeah. Wow. Okay, thank you.
Unless there's, I just ask that you affirm. Thank you.
Well, we're at that stage, as so often. There are plenty more questions, but I don't think we'll explore them further within this hearing.
Okay.
That concludes the argument in this case. We will take a 15-minute recess and resume the session at 11 o'clock.
Thank you.
Court is now in recess.
continue our session with the first of the three civil matters we have on for hearing this morning. Case number 2023 P661, James KEOWN versus Carol MICI.
Good morning. May it please the court, Michael Namcrane for Mr. Cowan. I'd like to start off with the issue about the standardized risk assessment tool. The commissioner, although she has tremendous discretion, she must follow the law. And as the SJC and Macaulay states, a standardized risk assessment is a consideration required by the regulation, and a reviewing court cannot acquiesce to its absence. So this is a clear violation of the law. She didn't do, the standardized risk assessment wasn't done, and Macaulay dictates that it must be remanded for that reason.
That is standardized, I'm sorry, is that an individualized risk assessment as required by 501 CMR 17.043, or is that somewhat different?
It's the actuarial risk assessment, not the sort of clinical risk assessment, sort of quasi-clinical that's spelled out in the
Macaulay's
regulations.
talking about the statutorily required.
Well, the statute talks about having a risk assessment done. The regulations talk about it actually being an actuarial risk assessment, like the Compass or some other tool like that. And that's what the Macaulay case touches upon. It touches upon the regulatory requirement.
And what is the triggering predicate to require the conduct of that risk assessment?
Well, the triggering predicate...
Let me back up for just a moment to make it clear what I'm asking.
Sure.
There are lots and lots of applications for parole that have nothing to do with the medical parole statute. There's no need for a risk assessment tool to be performed in those instances. What raises the question here is the presence of a medical condition that may bear on the level of risk. But does any claim that I suffer from a medical condition trigger a risk assessment, or does the medical condition need to be of a particular character and a particular severity before we get to that requirement?
Well, Your Honor, I think, and forgive me if I misunderstand your question, you talked initially about parole.
I'm talking about medical parole now. I just put the other one out there, but I mean, let's say there's a medical parole. I suffer from asthma.
Okay. Well, the predicate is the petition. When a prisoner petitions for medical parole, that triggers a legal process that includes that actuarial risk assessment.
So, just to go back then, your contention is that if I file a request for medical parole and claim as the predicate basis for my entitlement to medical parole the fact that I suffer from asthma, it is incumbent on the commissioner to conduct a risk assessment using that risk assessment tool.
Well, that's an interesting question, Your Honor, but let me...
Thank you. I'd like an answer if you have one.
No, because I was actually thinking about this just before I walked in there, because the Buckman case talks about who has the responsibility to come up with the diagnosis. So, for instance, if I was a prisoner sitting in my cell and all of a sudden I had a really hard time breathing, it was causing me tremendous distress and so on, using asthma as an example, I'm not responsible under Buckman to diagnose myself.
But before we get to the question of burden, what I'm asking you is, does the reference to any medical condition whatsoever automatically trigger the requirement to conduct a risk assessment, or is it necessary for that medical condition to be one that meets certain criteria, either in terms of character or in terms of severity?
Well, the statute requires that you have a condition that renders you permanently incapacitated. That condition, like for instance, in STP cases, we don't have...
In your argument, in your brief,
right.
I understand you to be taking the permanent incapacity as being one that cannot be answered without conducting the risk assessment.
Whether you're eligible for medical parole cannot be answered without doing the risk assessment. That is a legal requirement that even in Macaulay, where we have a petitioner in there...
Okay, you're right. Let me because in this case, I think it's fair to say that the evidence on this record does not establish permanent incapacity.
I disagree, Your Honor. Again, the fact, this case actually represents the troubling sort of situation we have where The Department of Correction is responsible for diagnosing the prisoner under Buckman, right? But so what the Department of Correction is saying, we can't diagnose this person, he's undiagnosed, which is not exactly true because there's 3 doctors on the record that talk about this person having a severe neurological disorder that renders him permanently incapacitated. This man is in a...
Oh, do they actually say they render him permanently incapacitated?
I think there is language in the record where one doctor, I think is at Chibi, talks about him being permanently incapacitated.
I thought
One
that was in
doctor says it and 2 others don't.
Well, there's Dr. Babu from Mass General who says he doesn't have ALS. She doesn't render any opinion as to his permanent incapacitation or not, but the DOC's own contracted doctors, one of them I think is a Chibi, I could be wrong, does talk about him being permanently incapacitated.
There was a diagnosis or a conclusion of permanent incapacity at an earlier juncture, and then a year passed, and his condition improved, and it was no longer clear that he was permanently incapacitated.
Well, I would disagree with the characterization he's improved. I would suggest that his condition has progressed, because what we have is, as time went on, he not only had these, he's stuck in a wheelchair and getting oxygen, but then there was also reports about his breathing, his eating being affected. He was prescribed pureed food. He was put on like a liquid diet, so he's not getting...
But the questions are about what's in the record.
Right.
So maybe we can back up for a moment. The standard for permanent incapacity is that a physical or cognitive incapacitation, one that appears irreversible, the one is mine.
Right.
As determined by a licensed physician, which I think is the question that we were just asking. And I'm going to insert the word "to," that it is so debilitating the prisoner does not pose a public safety risk. Now, the risk of violence assessment that you say is required by the regulations, appears to be required by the regulations, goes to 2, but it doesn't go to 1. So if in fact it was determined that he had a condition that was not irreversible, why would you worry about?
There's no opinion that it's not irreversible.
Okay, so here's the question. We have a finding. I'm going to call it a finding. We have a statement that he appears to have markedly improved. Right?
That may be what I think maybe Dr. Sullivan talks about.
Oh, it's what the commissioner said. Commissioner says he's markedly improved. So where do we have a finding by a licensed physician that he has a condition that appears irreversible?
Again, a condition doesn't have to be a diagnosis. We have doctors on the record that talk about he has a neurological condition that is affecting his ability. He's in a wheelchair.
It has to be irreversible in order to qualify him for permanent incapacity, right? Am I misreading the statute?
No, Your Honor.
Okay.
I just don't see any evidence that it's not irreversible.
Well, no, I would put it the other way. I think there has to be evidence that it is, doesn't there?
Well, he's still in a wheelchair. He's not in.
And he's markedly improved.
He's not. To be fair, Your Honor, and I apologize, this is not on the record, but he's been moved since this case, from the CSU at Norfolk to a more intense facility at Shirley. He's not improving.
Well, that
So
really
that's off
is
the
not.
record. That's
I know,
not the
but
question
I'm just
reviewing.
but
There are a number of neurological conditions that are temporary in nature.
Yes, I apologize, I'm not a doctor.
Some of them can be quite debilitating, can lead to paralysis, the
Right.
inability to ambulate of any at all. The condition of this prisoner at the time of this petition was that he had a neurological condition of unknown origin and unknown extent that was severely affecting his ability to perform various tasks, but it was unclear whether it was reversible or irreversible, based on the medical evidence available to the commissioner at the time of the decision. Isn't that correct?
I would say there was ambiguity as to whether it was reversible or not. You're right about that, but I think that also...
Well, then so long as that there is a question of whether it is reversible or irreversible, then he is not it is not established that it is a permanent incapacity within the meaning of the statute. Correct?
Well, if that was, yes, I think if I may, Your Honor, I think I know where you're going.
Well, that makes one of us.
Right. Well, I think what you're trying, you may be, and I apologize if I'm wrong, I think you may be trying to reach to what the Department of Correction is going to. Is that
what I'm trying to do is understand how to apply the statute to the facts of this case.
Okay. Well, I think it's simple. I'm going to try to make it simple. Macaulay talks about, well, let's talk about Mr. Macaulay. Macaulay was a person who was a murderer. He was a mess in prison, had disciplinary reports, would refuse treatment for his substance abuse, and so on and so forth. Clearly not eligible for medical parole on at least on the second prong about risk. Nevertheless, Justice Cipher said we must have a remand because they didn't do a standardized risk assessment.
I understand, but there was no question about his permanent incapacity.
Again,
and then what I'm trying to get to here is whether we reach, I started off with asthma.
Right.
Asthma may not be that much of an incapacity. It's probably permanent. But in this situation, we don't necessarily know that we have an irreversible condition. And if we don't have a permanent incapacity, we don't satisfy prong one, we don't move to prong two.
I don't think it operates like that, Your Honor. I think again, the way I read Macaulay is that we don't take this as, incrementally. Is that the assessment that the commissioner comes out with, and the assessment that the superintendent transfers the commissioner must include the standardized risk assessment. That is a legal requirement.
It's not an irreversible condition. I understand your point. Maybe that's a way to read Macaulay. Let me ask a question slightly different.
Sure.
Okay? Let's assume we don't agree with you with respect to how Macaulay is to be read. And instead, we're going to read the statute as having two different components, one of which is that he has to establish that it's irreversible. What evidence would you point to that is irreversible as determined by a licensed physician? Where should we look so that we can find that you've met that?
Well, I don't see that he has a condition that's progressing, I would argue, that in the record. Now, let's suppose, for instance, we'll accept Dr. Babu's conclusion that it's some psychosomatic disorder. That doesn't mean it's not a condition under the statute and regulations. It's still affecting him. It's still causing him to be in a wheelchair. It's still affecting his breathing, his movements, his swallowing.
But you understand the tension, don't you? I mean, if it's psychosomatic, it could dissipate entirely following his release.
Well, then the law is clear on that. He comes back to prison.
By then, he's in Missouri with his family.
And the parole officer in Missouri takes him back in, and we transmit him back to Massachusetts.
I don't find that argument particularly powerful.
That's how the legislature set up the law. That they anticipated that.
It cannot be that. The legislature set up the law to say that if it's not in the interest of society to release him, he shouldn't be released.
And it seems to me that the use of the term irreversible is designed to preclude release of someone who has a condition that could dissipate entirely on its own.
I think, though, and again, it's not before the court, but I think there are instances where people are being brought in because their conditions have improved in Massachusetts. And my brother can maybe better to answer that, but the law does anticipate,
but
even if something is
like, oops, we made a mistake.
Yeah.
I mean, they're trying to make the decision ex ante, whether this person has a condition that is permanent incapacity, that is irreversible, and that puts them in a position where, in the language of the statute, he will live and remain at liberty without violating the law, right?
Yeah, that is the law, Your Honor.
And that has to be so debilitating, prisoner does not pose a public safety risk.
Yes. And what we have here is we have somebody who has a condition, neurological, whether it's psychosomatic or something else, I don't think really matters under the law. It's causing, because if he was in a wheelchair and he didn't need to be in a wheelchair, I would not think that the prison would keep him in a wheelchair and keep him in the CSU and keep.
The fact that he's in a wheelchair, you I hope will concede, does not mean that he has a condition that's so debilitating he doesn't pose a risk, given the nature of prior conduct.
Well, no, because it's not just the wheelchair, Your Honor. It's the oxygen, it's the swallowing, it's the contraction of the hands, it's other things that have been recorded by clinicians in and outside the prison, that this person has a condition that's causing him significant distress, and he needs people to help wheel him around the prison. He needs people to take him, he needs to be put in an ambulance to go to appointments. The people, the doctors within the Department of Correction have found something severely wrong with this person, and they're treating him for it. And again, it's the response.
That takes me back to the question I've now asked twice, your time,
Sure.
which is, where would you point us in the record where I'm going to find the licensed physician who says the strongest case for you? The argument you're making.
I would look at the medical director, well-past medical director, and the director, and the Norfolk medical director, I think Achibi and Dr. Descoteau. They talk about his condition, and I think at least one of them talks about it in terms of being permanently incapacitated.
Justice Neyman has a question.
I just want to make sure that I completely understand this part of your argument.
Yeah.
My understanding is that you're telling us that regardless of the rest of this case, regardless of the DOC commissioner's findings, regardless of the evidence, McCauley tells us that the DOC regulation, I'm not sure which one, has interpreted an assessment for risk of violence to mean you must use a standardized assessment tool. One wasn't used here, so no matter what, at a minimum, the case must be remanded so that for the DOC to use one of those assessment tools in their analysis. Is that a correct summary?
That is a correct summary, Your Honor.
Okay.
All right. Thank you.
Thank you.
Why don't you start where we left off?
Thank you. That's my next question. Wonderful.
Good morning, Your Honors. May it please the Court. Scott McLean on behalf of Defendant Appellee Carol MICI, Commissioner of Correction. So this Court should not upset the decision that Commissioner MICI made in September of 2022 to deny Mr. KEOWN.
Was a standardized assessment tool within the meaning of the regulation used in this case?
No, Your Honor. So the tool that McCauley references is called the Compass Risk Assessment. It is an assessment that the Department of Correction does on every individual entering the department who does not have a life first sentence. At the time that, before this decision...
Right, but footnote 39 of McCauley sort of says, we may not presume that the risk assessment defined in the regulations pertaining to classification of prisoners is the equivalent of the risk for violence assessment. And they talk about the LSCMI and or COMPAS
Well, so the
tools.
classification report is something different.
Right.
The classification report is something that is done for everyone who is in general population on a regular basis to determine whether it is separate from the COMPAS. I'm not sure if that answers your question, Your Honor.
Well, let's go back. I just
Sure.
want to make sure. So you agree that the standardized assessment tool was not used in this case?
That's correct, Your Honor. So
How do you get around the language of McCauley that says, as long as that regulation exists, you've got to do it?
Yes, Your Honor. So this case, in McCauley's case, the commissioner also had in front of her a medical opinion that was more consistent with the permanent incapacitation that you had been asking my brother about more fully just a few moments ago. This was not the case in this situation. That, as you had been asking my brother about, the record that was in front of the commissioner was much more, I would say, unequivocal that Mr. KEOWN does not meet the standards of permanent incapacitation. So, yes, Your Honor. So, and Your Honor, you broke it down quite nicely, I think, before where...
You like the way I broke it down, but you do have this problem that Judge Neyman is on, which is McCauley seems to say you got to do a standardized risk assessment.
Yes, Your Honor. And so, as Your Honor had said previously, permanent incapacitation is broken down into two components. The medical component, which is the first, what Your Honor said was 1, and the public risk component, which is 2. The number 1 is the province of the medical professional. The commissioner gets a medical evaluation on once a petition has been submitted.
So what does that say? Because your brother says that though the record will indicate that they've found that he does have a condition that's irreversible or that, in their view, is permanent incapacity. What do you say to that?
That it was a permanent incapacitation?
No. What do you say to, your brother says, look, if you go look at the statements of the licensed physicians who examined this person, you will find that they say that he has an irreversible condition. Do they?
Well, what I would say to that is, Your Honor, is that was not the crux of the commissioner's decision, whether or not a condition
Well,
is
no, but we're here to
irreversible.
review the commissioner's decision. The question is what the record says about his condition.
Well, what the record shows, is that at some point around 2021, Mr. KEOWN was in a certain state, and that at another point in 2022, apparently he had improved somewhat. For example, he was now able to do certain ADLs where he hadn't been in 2021.
ADL?
Excuse me, Your Honor, activity of daily living. He was able to attend to certain of those, as was in...
Wasn't using oxygen anymore.
So there were instances throughout the record, yes, of the medical record from July 2022 to late August of 2022 to indicate that he was able to breathe normally and use normal room air. Certain of those records did.
So I still don't have an answer to this, and maybe it's not there, which itself would be interesting. What did the licensed professionals say about whether his condition was irreversible?
So if you want to reference, Your Honor, the second appendix, page 409, that was Dr. Sullivan's.
Okay.
That's the most recent medical evaluation.
Okay. So, and this was a medical evaluation considered by the commissioner in issuing the decision that's at issue in this case?
This was the one that was considered on the initial remand from Superior Court. So the decision that, for all intents and purposes, is being appealed today.
What does Dr. Sullivan say?
She goes through his history. There's uncertainty as the underlying etiology of his symptoms. At this time, there's no prognosis of less than 18 months. There remains a degree of uncertainty of life expectancy due to undiagnosed condition. I'm not seeing the words irreversible condition.
Or permanent incapacity?
Well, Your Honor, I would say that, contrary to what my brother asserted, whether or not the term permanent incapacitation appears in a medical evaluation
It would just be a legal conclusion, I understand, but does she say it?
She does not say that, no.
Does someone else, some other doctor?
I believe certain of the earlier doctors did use that term.
Earlier meaning in 2021?
Correct, Your Honor.
So what do we do with that? So somebody said in 2021, permanent incapacity, then in 2022, we don't have the same evidence.
Yes, Your Honor. What I would say is you would look at the evidence that the commissioner had before her on September, I believe it was 15th of 2022, where Mr. KEOWN was at that date. To Your Honor's points previously, these things can fluctuate. And what the commissioner has to determine is if at that time, Mr. KEOWN is permanently incapacitated, whether he meets the medical criteria, which she determines based on her medical evaluations, and whether he meets the criteria of whether or not he would not pose a danger to society.
And the latter of which, if that's at issue, does that require, seems Macaulay says, that requires a standardized test, right?
I would argue, Your Honor, that in this case, in making her consideration...
Well, I think you have to make that argument downstairs because that's what Macaulay says.
Right, we haven't let you answer this yet, so we're going to let you answer it this time. You've already told us no standardized risk assessment risk tool within the meaning of the regulation was used here, right?
Correct.
Macaulay says despite the fact that a standardized risk assessment is but one relevant factor that the commissioner could have considered, it is a consideration required by the reg and we cannot acquiesce to its absence. Full stop. Since it's not here in this case, how can we not remand? And we're going to let you answer that question, so give us your answer.
And again, I would argue, Your Honor, that the totality of the evidence that was in front of the commissioner at the time I don't want to say trumps McCauley, but that would be my.
Why don't you put that in a form that rests on a solid legal foundation?
Yes, Your
Much
Honor.
as we, on occasion, we might want to trump the SJC, but usually it's a bad idea for us to do so.
Yes, Your Honor. So the underlying facts, I want to go to the underlying facts of Mr. KEOWN's index offense. In 2004, he was convicted of murder of his wife.
We understand the underlying offense and its severity, and that's why he's serving life without parole.
Yes, Your Honor, but that also goes to his permanent incapacitation. That's that second prong of whether or not he would pose a danger to society. The fact of the matter is that his medical condition, as it is, would not prevent him from performing the
So
same
you're
sort of
saying
underlying
basically,
fact.
I'm sorry to interrupt, but you're basically saying here, the evidence is so strong and the Commissioner's decision is so sound that we can kind of ignore that mandate here. Is that effectively what you're saying?
Aren't you, I mean, let me put the same question a different way. What you're saying is that, that this is, the evidence here is so significant that we can reach the conclusion that he doesn't that he would pose a danger, even without conducting the risk assessment that McCauley says is mandatory.
Yes, Your Honor.
And perhaps it might make sense for there to be a case where we explain how broad the SJC's language is, and perhaps they might want to take the case and pull back a little bit from that statement. Or maybe not, I don't know.
Yes, Your
I
Honor.
suppose you could also rewrite the reg.
Or you could just do the thing. So why wasn't it done? Is there
So, Your
anything in the
Honor,
record
so
that
since
indicates why it wasn't
It's so clear that that would happen. What's the?
So Your Honor,
Well, it came out
since
after this, right?
I see.
So it, like I said, it was done. It is done upon entry of all incarcerated individuals. Except for life without parole individuals. So that was Mr. KEOWN's. Since McCauley has come down, when a medical parole petition is submitted, even by an individual with a life first.
I missed this point. So McCauley postdates the decision here.
This decision, yes. McCauley came down, I believe, in April of 2023.
So now you do them in every case?
Yes, Your Honor. Going for yes, if a petition is filed by an individual by or on behalf of an individual who is serving a life first sentence, the Compass risk assessment is done.
So the commissioner's decision was rendered when?
September of 2022, Your Honor.
And when was the decision of the lower court, right, on certiorari? When was that?
I do actually. I apologize, Your Honor. This was not my.
I've got it right here. Sorry, I shouldn't ask questions I can answer myself. April 5th, 2023, and the decision of the SJC
was on about around April
3rd,
April 3rd,
2023.
And I apologize, Your Honor. I think I could have made everyone's line of questioning a bit easier if I had started with that part.
Well, it's an active bench today. It's okay.
But we're not a grumpy bench,
That's
Richie. If you're out there. Okay.
So regarding the rest of my brother's arguments, as I said, and as Justice Englander broke down so nicely before, there's the two-prong component for permanent incapacitation, the medical and the public safety component. It is the public safety component, well, it's all of it that the commissioner must consider, but it's the public safety component in which she is owed deference as the commissioner of correction. And as I was saying earlier, given the facts and circumstances of Mr. KEOWN's index offense and the medical record that she had in front of her, the most recent report from Dr. Sullivan, as well as medical records throughout 2022 showing he was still capable of performing something similar to what he did to land himself a life first sentence. So the commissioner's decision in that regard was rationally based. Mr. Nam Crane also submits that a due process violation occurred because the commissioner did not consider certain video surveillance that Mr. KEOWN's attorney had requested her to consider. I believe it was 4 dates in 2021, another 5 dates rather in 2022. The statute quite simply does not say that the commissioner has to review video evidence, nor that the petitioner can dictate what she has to review. The statute lays out what she has to review: the medical evaluation, the risk assessment, the statements from the ADA and any victims'
Does
families.
due process clause apply?
No, Your Honor. So my brother makes the argument that because she did view a video from the day before she rendered her decision of Mr. KEOWN in his unit.
My question goes in front of that. Does the due process clause apply?
No, Your Honor.
And why not if there's a liberty interest at stake?
Because, Your Honor, just because the liberty interest is satisfied by the rest of the medical parole process. That's the point of the medical parole process.
I mean, that's not the way that, it's not the way the United States Supreme Court thinks of these issues, and I'm pretty sure it's not the way that the SJC thinks of it. The first question is whether there's a liberty or property interest. If there is, then due process applies. Then you have a question of what process is due. Those questions are separate. That's Cleveland Board of Education against Loudermill. So, is there a liberty interest here?
What? Well, so I would say there would not be an interest in submitting specific video.
No, but that's not the point. I mean,
that mashes all three of those considerations together. Liberty interest involved. If so, then due process applies. What process is due?
I mean, you argued in your brief it doesn't apply. He argued that it does apply. It's an interesting question, right? I mean, this is a person who's had all the processes due to be convicted and sentenced to life in prison without parole. And then somehow this statute arrives, and the statute has the word shall in it, which suggests maybe it creates rights, maybe. And if it does, then there's a liberty interest. If there's a liberty interest, then you got to talk about what processes do in connection with the liberty interest, right? He says, hey, you looked at, he meaning your opponent, you, Commissioner, looked at video of my client from the day before you rendered your decision. My client tried to put in other video and you refused to look at it. That's not fair. That being one of the touchstones of due process. What do you say to that?
It's perfectly fair. The video that she did view was the most recent video of him on it. Literally, she could have viewed of his.
Chosen by whom? Edited by whom?
Well, that I can't speak to because I don't
know.
Right.
I mean, isn't that the issue?
Well, but Your Honors will be able to see the video. It's in the record, but it is the video of him being active on his unit that day before. And again, Your Honor, as opposed to your question about fairness, as opposed to videos that were specifically selected from different data points, I mean, in terms of fairness, Your Honor, any video on any given time.
I'm sorry, I should know the answer, and your time's up, so I apologize for interrupting, but did the Commissioner address directly why they chose not to look at the other video?
Not in her decision, Your Honor. I mean, there are the issues of, logistics, of her having to view 6 hours worth of video for every decision that she has to make. And again, in terms of fairness, it's sort of proving a negative sort of situation. She has to see whether or not he could pose a danger, whether or not he is able to perform any of sort of the functions that he, for example, did to get in his index offense. And so I would suggest that in terms of fairness, a review of him, of a video of him going about his day on his unit the day before she made her decision, that's much more fair than, again, 6 or 7 videos from specific time frames that were chosen. Because again, like I said, it's easier to prove a positive than a negative.
Thank you.
Right. Thank you. That concludes the argument in this case. We move to the 5th case on our hearing list this morning, case number 2022 P1102, SAM CHIU versus LIANXIANG FU.
Good morning. My name is Charles Devine. I represent the plaintiff, SAM CHIU, plaintiff appellant. This case involves a divorce action to terminate a 25-year-long marriage that resulted in one son who's presently 27 years old. The son was raised primarily by the plaintiff father, while the defendant mother, Ms. Fu, attended graduate school, worked as an engineer at which she was not successful, and when her endeavors proved to be unsuccessful, she worked with the husband's help to enter the restaurant business, ultimately owning 2 restaurants and a catering company.
So already we're off in a world that makes me uncomfortable. She did it with the husband's help. That may have been the husband's testimony, but not only is there not a finding that she did it with the husband's help, there is a finding that he did not help.
Fair, Judge.
Well, but then you can't, if you want to say that, you have to tell us, I'm about to tell you something that is contradicted by the findings of the trial court and that I think is clearly erroneous, don't you?
Judge,
and we're not being grumpy. I apologize, but
I apologize about that, Judge. And clearly, it's our the basis of our appeal is that the findings are erroneous and that the evidence wasn't adequately considered by the trial court, and that the trial court made errors that prevented relevant evidence from being submitted at trial, that enabled...
Yeah, there are a lot of issues, and all I was doing was trying to make, because it seems to me this particular fact is in fact relevant to part of your arguments, right? To the extent that he participated in her creation of property during the marriage, that goes to your point that he wasn't allowed to put in evidence of what property she owned in China.
I don't believe that that was the reason why the evidence was excluded, Your Honor. The evidence...
No, but it bears on
whether there's
what weight,
prejudice.
what importance that evidence would have had at trial, because if the assets were acquired wholly independently of the husband's participation, then it wouldn't matter, right? Or the judge could conclude that.
Well, at trial, so if we were to pop back then at the time of trial and when this issue arose, the judge would then be confronted with the situation as to concerning whether the defendant had been committing a fraud upon the court, submitting false affidavits, not answering discovery, hiding evidence that is located in China.
That may be the basis for the imposition of sanctions, but going to the division of marital property, the foundational question that the judge has to confront first and foremost is whether they were the product of the marriage or whether they were acquired independently, right?
Fair, Judge, and that decision is made as a result of the deliberation and consideration of the evidence to be submitted. Now,
I understand, but the point is, I guess, one point. There are lots and lots of issues here. But one point is, quite apart from whether the judge should have allowed this material to be brought forward, quite apart from the question of the contempt, quite apart from the decision to exclude the evidence because it wasn't translated into English, all of that. The question whether the husband contributed to the acquisition of those assets is something that is not uniquely or exclusively within the wife's control. If the husband made contributions to the acquisition of those assets, the husband could have made a proffer of what those contributions were. There is nothing of that sort on this record, right?
There is nothing in the plaintiff's case that if we call it a basket of documents, that's the documents acquired from China, were allowed to be submitted into evidence, that basket of documents would have contained evidence that would be relevant on those issues.
What it would have showed, I'm sorry to interrupt, but it would have shown what those assets were.
Yes, that too.
What is the evidence in the record before us that would have shown that the husband contributed to them?
Well, the evidence would have shown how and when the assets were acquired. They would have shown, they would have contained documents and letters.
How do we know
there were also photographic albums.
Everything you're saying right now, was there a proffer made at trial or before trial such that the judge could say, oh, or such that we can say, oh, that's what we're missing here? Where in the record can we find that?
Well, throughout the pretrial record, as well as the testamentary record, there are references to the documents and what they would have shown in the nature of formal and informal offers of proof. A trial counsel would say, the records from China show this, this, and this. Isn't that true?
Is that in our record?
That is in the record, Judge.
And what do they show about the husband's contribution to the acquisition of those assets?
I don't know that there's any specific reference to the husband's contribution.
Isn't that the foundation? I mean, there's lots of interesting, or there are lots of interesting questions about the scope and value of these other assets. But unless and until there is a connection to the husband's contribution, that doesn't really matter very much, does it?
Well, I would disagree because 208, Section 34 entitles the homemaker to a portion of the assets that are collected during the marital enterprise.
As a general proposition, that is true, but this was not a prototypical marriage with a shared commingled household, was it?
It was for many years. And it was on and off. So for a period of 3 years, when the child was 3 until he was 6, child and father lived in a different city than the mother as she was starting up the restaurant business. Then they lived together for a period of time. And then the husband moved to the United States with the child and cared for the child in the United States from, I think it was age 10 or 12 to 15 or 17, at which time the child was educated, the father cared for the child. The mother visited frequently, but it was the father that was a primary caregiver of the child to allow the mother to work on the family estate, that being the 2 restaurants and the catering business, as well as the purchase of the condominiums.
Well, I'm sorry, if my colleagues are okay, we need to back up, because one of the things about operating as a panel is we don't always see things the same way. And I'm stuck at the beginning with what evidence is there in the record of what these documents would have shown. Now, in answer to Judge Neyman's question, you said there were formal and informal offers of proof the documents would show X or Y. It sounds to me, just give me a yes or no, that wasn't done at trial, that was done before trial.
I would say it was done both, Judge. I think that.
So there's an offer of proof at trial as to what the documents would show?
I believe it can be considered an offer of proof, Judge. It was sort of an argument during a witness, and I can't remember. I think the witness was the wife, and the argument was about the Chinese documents and about the fact that they showed what the properties were, the fact that the wife claims to have sold them to the brother, yet there's no documentation for that.
And that's a trial transcript.
That was in the trial transcript.
But there's also going to be transcripts in argument to the special master about what these documents would show?
I believe that there is.
I did not pick this up from the briefs.
I think I recall some motions in which there was a motion to reconsider to the court that was denied without comment.
Because it seems to me what you have to establish is that these are assets of the wife, that they are assets acquired during marriage, and then perhaps, as the Chief Justice is pointing out, that the husband had some participation in the creation of that value. And what I'm trying to figure out is, where am I going to find that in the record?
I don't believe that third element is a crucial element, however, Judge. I mean, I believe that
it might be in this case.
It's that's the husband's position for sure. And certainly, there was a finding by the court that there were no marital assets, right? Or the marital assets, and those assets were the sole,
Back to my question,
solely owned by the
where
wife.
am I going to find that in the record, that they were the assets, that here's proof that the wife had assets in China, here is proof that she still had those assets, here's, well, yeah, let's just start there. Here's proof that the wife had assets in China. Where am I going to find that?
So the proof is missing, which is my case, which is my appeal. The proof is missing because it was excluded.
You had the documents.
But the offers of proof were
You
there.
had the documents, so
At
where?
that point, the documents were turned over to the master, who then delivered them to the wife's
That's not an
counsels.
answer to my question. We can't, it seems to me, I'm going to have trouble overturning a judgment of a court where you haven't shown that, in fact, those documents showed what you say they did. Where am I going to find out that those documents, had they been translated, would have said she had the following assets in China, and they were acquired at a particular time?
At the trial, I believe that it would be the trial counsel's obligation at that point to make a good faith offer of proof to the judge as to what those documents would have shown, and she did that. I believe that the record is complete with a description.
Where did she do that? Where should I look?
Your Honor, may I submit a supplemental letter either today or tomorrow outlining the specific page of the
Offer of proof?
I do believe that we've made adequate references in the brief, but I can write a letter and be more specific as to this specific pages.
That would be helpful.
So, sort of moving forward to the errors, and I'd like to discuss the errors in more specifics. So we're now in August of 2019, and the documents have been acquired from China by father, or by the husband, who was frustrated at the fact that the plaintiff has been denying the existence of these documents, has an order compelling her to reply. Later in September, there was a date for compliance, and she still hadn't complied. So he went and got the documents themselves. An order of contempt was then issued around October 3rd, based upon what we consider to be.
I'm going to cut you off again just because there's not a lot of time and there are a lot of issues.
Okay.
On the contempt, okay? Let's assume we agree with you, for purposes of hypothetical purposes only,
Okay.
that there wasn't sufficient evidence of contempt. Why is that significant? What sanction was issued? What is it about that decision that had any impact on your client?
That the finding of contempt now operated as the foundation from which most, if not all, of the future errors arose. So in other words, the finding of contempt was then the basis for the master to rule that you were finding contempt, therefore you can't put those documents on the trial list. That then moved to the judge, who was asked to reconsider that. And
Who found contempt? The judge? Did the judge issue the contempt order?
The master issued the contempt order.
Is the order in our record? Because I looked and I think I had trouble finding it.
Finding the order of contempt?
The order of contempt.
Okay.
Judge.
I'm sorry. Okay, I'm sorry. I'm just been corrected that the judge issued the contempt.
So the judge issued the contempt. Is the order of contempt in the record?
I believe it to be in the record, Judge. And again,
when you submit, again, we don't, speaking for myself, I don't think we're looking for a lot of argument, but if you can identify the page of the record where the contempt order is, that would be helpful.
I will, Judge.
And what you're saying then is the contempt itself, what was the sanction that was issued with the contempt order?
At the moment, I don't believe that there was a sanction, but the sanction arose later when it was asked, when trial counsel asked to add the documents to the evidence list at trial, and that was denied by the master, and then the judge was asked to reconsider it, and then denied it. And from that point forward, then counsel said, well, we can get the same evidence in through these certified records that came from China, from the Chinese counsel that the husband had hired. He delivered them with the certification. The judge denied that motion because the documents, because discovery was closed, not considering the fact that these documents were actually the defendant's documents that she
That was the
didn't produce.
representation that was made, that they were the defendant's documents.
Well, it's a representation made by the defendant. The defendant said he went into my house that he had no right to be in and took my documents. Therefore, Master, I want you to make these orders.
The documents were in Chinese characters? Untranslated?
I have not seen the documents, Judge, but I would assume so.
At what point did the discovery master order the translation of the documents?
There was never an order for translation, which is my point. And now this is an issue now that, you know, I've been practicing for lots of years, and this is an issue that I've only really came across over the last several years. It's really becoming more and more prevalent, but there is no rule in Massachusetts to address that. I was in the federal district court recently where they don't have a rule on it either, and we were able to find a rule in southern Florida that addresses translation of documents, but we did some pretty exhaustive research, and we really were convinced that it's sort of a blind spot in
The important thing is, before the master issued that order in which the master said, I'm not going to let you do this, the master had never said you need to translate the documents.
Master never said you need to translate the documents, nor did the court. And so this was just all of a sudden, I'm not going to allow them in because they were not translated, and there was no predicate order on which that sanction of exclusion was based. So, and plus it was 2 months before the trial. So there was plenty of time to get the documents translated before trial, but counsel was not given that opportunity. They were just excluded. And then there was the other issue of the evidentiary issue of the admission by now a witness. Okay, so the Chinese documents certified were not allowed in. So now there's a live person that lives in Cambridge that is a partner of the defendant in another business in Cambridge that can come in and testify. Yes.
Your time is up, and I'm sorry to interrupt you, but I have one more question. Justice Englander asked you a question about the proffers made both before and during trial with respect to the so-called Chinese documents. I just want to make sure I understand this. You say that the proffer was, one, they show that there were these Chinese entities set up, and two, it would show that these were what these assets were worth. But three, if I heard you correctly, the proffer was not made as to how the husband contributed to these assets.
I think that is correct, Judge, but there was also a 4 and a 5. They also show that these properties that was in the defendant's name were sold to her brother after the case was filed and the defendant was served with the complaint in violation of the
I got that. Okay.
Did they show the consideration?
I believe that I believe that there's admission at trial that they were nominal, that it was nominal consideration. I think I recall $15.
Gift transferred. All right, I think we're going to have to leave it there. Thank you.
Thank you, Judge.
Good morning. For the record, my name is Attorney Jack P. Milgram for the appellee, Ms. Fu. It's our position that the judgment of the Middlesex County Probate and Family Court should be affirmed in full.
Could you speak up, please?
Yes.
The fan's on.
Yes.
Thank you.
In regards to the documents in the laundry basket, what do they show? It's an unknown, as we stated in our brief. There was an order from the Middlesex County Probate and Family Court to the husband to provide an itemized list. He never did it. There was an order from the Middlesex County Probate and Family Court to provide copies. He never did it. He never had them translated.
Was there an order requiring them to be translated?
No.
But
there
let's
was
go
not.
back to 1 and 2. My reading of somebody's brief was that he provided a partial list of what the documents were. Wasn't there a partial list provided?
I was a trial attorney, so whatever was sent to me. There were scans, and I'll leave it to the court to decide. I don't really think scans are copies. There were scans of certain documents that were sent to me.
Is that all of the quote-unquote Chinese documents were sent to you by a scan?
No, only a small portion. Only
You
a
got
small
some.
portion.
Some were provided to you. They were all in Chinese.
And they were all in Chinese, that is correct.
And they also offered to have you come and inspect the documents.
Yes?
Okay.
They did. They did.
What's wrong with that?
I can't, because if I'm going to go and inspect the documents to begin with, I cannot read Chinese. That's number one.
Yeah, but you're going to have to bring somebody to do it. That's the way this works.
Number two.
Your client operated in the Chinese language.
My client operated in the Chinese language.
So your client can help you understand.
The parties operated in the Chinese language, but the case law is clear, as stated in our brief. Our system operates in the English language. The judges work in English. The counsels work in English. And it's within the discretion of the court how they administer that. And it's not, and there were cases that we cited in our brief.
But this doesn't help you, counsel. Because all you did is you wanted to see the documents. And they said, which is, by the way, I'm an old guy too. When we used to do Rule 34 productions, if I recall, Rule 34 says that the first thing you do with a production is you allow the opposing counsel to come and inspect the documents. That's literally what the rule says.
Okay, but that's for discovery.
Then we started making copies and giving them to people because it was a lot easier. But he essentially offered to you exactly what you would ordinarily do in a discovery context. And by the way, as I understand it, may I?
Go ahead.
As I understand it, a lot of these things were photographs?
No.
No, that's what it said in the documents. And it's very hard to make a copy of a photograph. So here, come take a look. What's wrong with that?
There was a lot more than photographs, and I can say that with certainty because that laundry basket's been sitting in my office for a very long period of time.
Did they then provide you the laundry basket?
No. What happened was, and it's in the record, the probate and family court judge ordered those documents to be provided to the discovery master. And after the discovery master made his ruling, then it was ordered to be put in my possession to be held. That's how I have them.
Did you get them before or after trial?
I don't remember, so I'm not going to misstate. I don't remember. But we're not talking about discovery. We're talking about trial. We're talking about getting ready for trial. And as a trial attorney, I cannot prepare for trial if I don't have copies of the documents. And the order was not for me to go and look at them, and then if I wanted to myself to go make the copies. That was not the order. The order was for him to make the copies. So
what exactly was the order? As I understand it, the initial order was given verbally, and then there was a documented order that came after Labor Day. Is that right? What exactly did the order say?
the order said that the husband was to provide an itemized list of the documents that he retrieved from China, and that he was supposed to provide copies of the documents, and he was supposed to do it forthwith.
Said both things, provide an itemized list and provide copies?
That is correct, forthwith.
Record Appendix 178.
That's what the order was. And that did not happen. And so we filed our complaint for contempt, we had our hearing, and as you know, he was found guilty of contempt. And it was at that point that the husband was ordered.
But as I understand it, the hearing was after he had provided some documents to you by copies, he provided some sort of list, and he'd offered to have you come and inspect the documents at his office, right? All those things that
There were
occurred.
scans of some documents, no list. They were in Chinese characters. I don't know what it is. No list, a scan of some documents, and an invitation. That's correct. But I'm a trial attorney. I'm getting ready for trial. I need to look at everything. Going to opposing counsel's office for 1 hour and looking.
Did he say you can only come for 1 hour?
No. That's not the point. The point is, without copies, I cannot prepare for trial. I can go look all I want. We're not talking
Are you
about.
saying that he didn't offer you the opportunity to copy the documents yourself?
That wasn't what the order was. That was
You
not
didn't
the-
answer my question, counsel. Are you saying he didn't offer you the opportunity to copy the
The
documents
question was
yourself?
not asked. So I'm not saying that. The question was not asked, but that was not what the order was. All right.
Is the contempt order of the judge in the record?
I believe, yeah, it is.
Can you tell us where?
I will tell you where before I finish. I prefer not to lose time.
Okay, well, I want to back up.
Yeah.
Your opponent has represented to this court that there's a document someplace where your client represents that the documents that we're talking about, this laundry basket full of documents that were taken from China, were your client's documents. Is that true?
I apologize. I'm not sure if I quite understand the question. If you
Were
could
those
restate it.
documents your client's documents? The documents that are in this laundry basket,
Yes.
were those your client's documents? Is there, and is that in the record?
I can't answer that. I cannot possibly answer that. I don't
You can
I don't
answer the
know
question whether it's in the record,
that my client said that they were her documents?
or that someone on behalf of your client represented that they were her documents.
No, I think what was represented is that those documents were removed without authorization from a property in China owned by her family.
Okay.
But in regard to exactly what those documents were,
There are no
we had
representatives.
not looked at those. So I
You're
don't believe
saying
so.
to me that when I go through this record,
Yes.
I'm not going to find any indication that anyone has an admission from your part as to what's in those documents or as to whether those documents are your client's documents. Because obviously, if the documents are your client's documents and there's a representation in the record that these are your client's documents, most of the argument you're making to us today falls on my deaf ears. They should have been produced in discovery. Right?
I don't believe you're going to find any such admission.
Okay. All right. But you understand my point?
I understand what your point is. I understand what your point is.
And that, it seems to me, is part of the difficulty in reading these briefs, right? I mean, this is what your opponent is saying. They're saying, hey, we went through this whole mess and were precluded from putting in evidence that should have been produced to us in discovery because they were the client's documents. They were my wife's documents. And if that's actually in the record somewhere, that they were, in fact, your client's documents and that you somehow got them precluded from trial, I got a problem with that, don't I? I mean, does that sound right?
First of all, I don't think that you're going to find that in the record. That's not my recollection.
Okay.
Of course, it was a 5-day trial. I'm not sure if I can remember everything, but I don't believe you're going to find that.
We don't have to rely on memory, we can just look to the record if we can find what's in the record.
I don't mean to interrupt. Even so, even if you do find that, it does not change the fact that in order to be able to work with those documents at the trial court level at the time of trial, they need to be translated, and they were not.
I couldn't disagree with you more. I'm sorry. If those are your client's documents that should have been produced during discovery, there's no way you can gain an advantage at the time of trial by excluding your own client's documents from trial by saying, I don't understand them. Particularly when your client, apparently, if they were your client's documents, she would understand them and she would be able to translate them for you. But of course, we're talking hypothetically. We don't know. We'll have to look at the record.
We're going to have to look at the record. I don't believe you're going to find that in the record.
So you mentioned admissions. There's an argument made in the opposing brief that says that the judge incorrectly excluded your client's admissions. Specifically, your client purportedly made admissions to a witness to the effect of she had made an investment, I think, of $300,000 in one
Membership
entity.
interest in an LLC, that's
and
correct.
also about her assets having to do with the sweet something. I'm going to...
Sweet catering.
Sweet catering. And the judge excluded that. How is it proper to exclude those if they're statements of a party opponent?
Because I think when you go back and take a look at the trial transcript, as I've
752 and 753.
As I've argued in the brief, I would state that there was insufficient evidence laying a proper foundation for the trial judge to determine that they were admissions, and therefore it was within her discretion to exclude them. I don't believe a proper foundation was made.
What foundation is necessary? Did she make a statement to you? Isn't that enough?
Well, if you go back and look at the transcript, I don't believe the statement that were allegedly made by my client to the quote-unquote partner was clearly an admission.
Doesn't have to be an admission. It just simply has to be a statement of a party opponent. It's not hearsay. As I read the rule, am I wrong about this?
Their position is their position is it was an admission. That's what their position is. They're the one that argued it from that point of view.
Are you arguing there's no foundation because the conversations were through WeChat and it wasn't
No, I'm not necessarily saying that. All I'm saying is, in researching the case law and preparing my brief, and comparing what the quote-unquote statements were in the cases that I looked at and the statements here, to me, it was not clear as to what was being said. That's my position, and because of that, the judge did not abuse her discretion. But what I'd like to say, if I may, to be clear in regards to relationship with the parties, the evidence was very clear at trial that after 2003, for all intents and purposes, other than there was in a piece of paper saying that they were divorced, these people were not together anymore. From 2003 to 2009, they lived in different cities in the People's Republic of China. From 2009 to 2013, they lived in different countries. Except for 2 weeks in 2010, they didn't see each other for that 4-year period.
They formally separated?
Not in a legal sense. If you're asking me if they went to a court, no.
No. I mean, when you say not in a legal sense, I mean,
that's
sort of where we are for purposes of determining this. And the question of whether the husband contributed by caring for the couple's child while the wife was working full-time to generate a business that had substantial value. If they are living apart while she does that, but not formally separated, ordinarily the husband's contributions to the marriage would factor in.
It's a factor to be considered. However, as I heard previously, one of the justices say, this is a unique case to a certain extent because of the long period of time where they clearly were not living together.
And I do have a question about that. Let's assume that there was evidence that your client owned property in China. Do you still have an argument that what the judge did here was within the judge's discretion? Do you still have, I mean, this just goes to the application of Chapter 208, Section 34. I mean, let's just assume that there were such assets and we don't know what they were. Do you still have an argument that this can be affirmed? And how would that run? I understand I'm asking you to assume something you don't want to assume. I understand that, but just follow me. And
I'm almost running out of time. I want to make sure, though, what it is you want me to assume. Assume that the judge found the opposite? Is that what I'm being asked?
Well, I don't think the judge made any finding about whether there were assets in China or not. I guess what the judge said is it wasn't proved.
The judge did make a finding. The judge said that the husband did not meet his burden of proof by preponderance of the evidence that there were assets in China. She did make a specific finding. She said the burden of proof was not met.
Fair enough. So I guess my assumption is let's assume that that was clear error because there was a preclusion of the opportunity to find that or to put that evidence in. Just assume it for now. Do you still have an argument for affirmance?
I don't think it really makes a difference.
And why?
And why? Because of the nature of their relationship when they were in China. During that period of time, they were not together. And I don't think that there was a clearly erroneous finding in regards to the husband's lack of contribution towards the acquisition, preservation, or appreciation of those assets.
And the husband testified, right? The husband testified.
He testified for 2 days.
Right. And the judge found
he wasn't credible on most
didn't
issues.
contribute to any of the wife's assets.
That's correct. That's correct.
All right, we're going to have to leave it there. We're over time, but thank you both for your argument.
I have one inquiry. I understand that opposing counsel is going to have, I guess, a day or two to submit something.
Simply to identify the location of certain documents that we've asked about that are in the record. It's not going to include argument.
Okay, just all right, to be clear.
But if you believe there's a misstatement in there, I think you would have the opportunity to respond.
That's what in case it's necessary.
Yes.
Thank you. Thank you.
Thank you.
That brings us to the sixth and final case on our list today, case number 2023 P378, Gary Pettiford versus Branded Management Group, LLC, and others.
Good morning, Your Honors. Thank you for allowing me to brief this and argue this. My name is Janet Ruggieri. I represent Gary Pettiford in this case, the appellant. May it please the court, the issue today before the court, and I will not go through the facts or the procedural history. A decision was rendered in May of this year, I believe it was, that the Public Accommodations Civil Rights Act, retaliation, intentional infliction of emotional distress, and 93A allegations were all dismissed because of a finding by the judge that there were not the actions of employee one who made a racial epithet to the appellant. She was not acting within the scope of her employment when she did so. So the first issue that I'd like to address is the fact that the 12b-6 standard does not require the judge to go any further than finding whether or not there's what's called a prima facie case, and there's a plausible set of facts that show that the plaintiff has a possibility of obtaining the relief sought. So in the judgment, the judge did find that there were plausible claims for the civil rights violation, public accommodation, and 93A, but went further and did the analysis of whether or not the employee one was acting within the scope of her employment. The case law will show is a question of mixed fact and law. And if it were pure law, certainly we would not be here today. But the issue...
The judge seemed to approach that question as one of pure law by applying an analysis saying that when the employee operates in a manner that is improper under the law, then by definition they are operating outside the scope of the employment, because the employment expectation does not envision having the employee act illegally.
So, Your Honor, that is correct, I believe. He used the respondeat superior liability argument, and the scope of employment there is defined as whether the individual is performing the job for which they were hired, whether they are doing it within the authorized time and space limitations, and whether it's motivated at least in part to serve the purposes of the employer. So it is our position that this was within the scope of employment. This was an employee who was a cook at Dunkin' Donuts. She was standing behind the counter. She was serving constituents, third parties, who do not know what her relationship actually is relative to that employer. They simply know that she is behind the counter and she is serving individuals. She issues a racial epithet at my client. She also delays the order and tells him he can wait and so forth. Our position is that that was within the scope of her employment. It was not that, as the judge said, the employer did not hire employee one to issue racial epithets at individuals. There's no question. But the issue is that in the course of her duties, she escalated a situation with this constituent and made a racial epithet to him. So there are two issues here. Respondeat superior liability attaches when the employer knew or should have known of the alleged conduct and fails to remediate it. However, that is always used in employment cases, and public accommodations cases are not typically brought in the Superior Court. They're typically at the MCAD. They in fact are the decision maker in many public accommodations cases. They use apparent authority because it's a third party. It's not an employee-employer relationship, even with the victim.
Can I stop you right there? 'Cause you're getting to a question I have, which is, you're familiar with the three-part scope of employment test from Wang Labs and from the Berry case?
Yes.
Do you agree that that test applies here?
What I would say is that the judge,
Does it apply to the public accommodation count?
certainly. So on a 12
Whoa, really?
I'm saying on a, I'm sorry, I haven't answered the question.
Oh, I thought you said certainly.
So, no, I'll answer the question.
Thank you.
So, does the scope of employment as defined under Wang apply to a public accommodations case?
Yes.
Plaintiff or appellant would argue that it does not, because this is not a respondeat superior case. It's an apparent authority case, because this is not an employee, this is a third party.
Okay, but let me stop you right there, and then Justice Englander is going to ask you a whole mess of questions, but before he does, I'm going to get my...
Or I mess it up.
No, not at all. Does it apply to the other causes of action here?
So I think that the scope of authority, the scope of authority test has been applied, was applied by Judge Reardon in this case. Can you apply it to this case? The issue is whether the employee one in this case, was acting inside or outside the scope of her employment, right? And so the issue then is whether she was inside the scope of employment, whether she was motivated in part to serve the employer. If she's acting outside the scope of employment.
Because I'm going to ask you questions about that third prong in a minute.
If she was, if it's a third party, generally an apparent authority standard applies, and if the employer was negligent or reckless in retaining, supervising, or hiring that employee, that conduct is attributed to the employer.
Okay. Now, just to go back to your first answer, you said you do not think the Wang framework applies to the public accommodation statute. What's your authority for that proposition?
Well, if you look at Ellerth and you look at Merrimack, the issues, and Sahir, the issue is not a respondeat superior analysis, and I would assert that the scope of employment question, that three-prong Wang analysis is a scope of employment
Right, so
analysis.
Sahir is an MCAD case, right?
Sahir is an MCAD case.
How about the other two?
Ellerth is a Supreme Court case. Ellerth was Burlington Industries versus Ellerth. And Merrimack College is Merrimack versus KPMG. It is a Supreme Judicial Court case.
And you're saying that case, are you saying it indirectly stands for that proposition or directly stands for that proposition?
Both Ellerth, let me talk to Ellerth first. Ellerth was essentially co-workers who were sexually harassing, no, I apologize, it's the other way around. Farragher versus Boca Raton, who also deals with apparent authority. Farragher was a case in which co-workers were sexually harassing her as a lifeguard. They were also lifeguards. And the question was whether they were acting with apparent authority, whether the employer could be liable for not remediating or for recklessly and negligently retaining those individuals. And the court found that there was cause to believe that the employer was liable in that case because they did fail to remediate the case. Also, if they aid or incite the agent in taking the actions that they do, then there's direct liability.
And I don't recall the citation to the Merrimack case, by the way, in your brief. I must be mistaken.
I can find it for you, Your Honor.
Talking about Merrimack Valley Transportation?
Merrimack Valley versus KPMG.
Maybe I missed it. I don't recall seeing it in your briefs.
Your Honor, I think it is in the brief, but it is not, unfortunately, in the table of contents, so I apologize. I do.
That's okay. What's the citation to it?
Let me find it, Your Honor.
You know what? I'll find it.
I'm sorry.
Continue with your argument.
Thank you.
My colleagues, I'm sure, have lots of questions.
So from the perspective of a third party.
I don't understand a third party. This is where I got lost. You talk about apparent authority and a third party. Who are you talking about?
What I'm talking about is the fact that in a situation with a public accommodation, an innocent third party walks into a restaurant to ask for food. That individual has no idea what the relationship of the employees are to the employer, or if they're even employees. And in this situation, that is what happened, that the appellant walks into a restaurant and
But why does that matter? I mean, the claim is that they were employees, right?
Yes, they are employees. And
Right.
the question then
The
becomes...
claim is, I walked into a place of public accommodation, and I was discriminated against on the basis of my race, and that's a direct violation of 272-98. That's the claim. Whether you're a third party or not is not important. What is important is the person you dealt with was an employee of the place of public accommodation. And that's the allegation in the complaint, right?
That's the allegation in the complaint, but I think the public policy consideration around the third-party victim is that the third party, between the third party and the employer, who should be liable for the tortious acts of the agent. And case law has, and Merrimack speaks to this.
Yeah, the difficulty I have with this, I'm going to lay my cards on the table because the other side's going to have to address it. In the context of a public accommodation claim, I don't think we need to talk about vicarious liability at all. I think that there's a duty on the part of the public accommodation, on the part of the company, not to discriminate on the basis of race. They can't get away with that by saying, oh, my employee acted outside the scope of my employment. They have a duty.
But we would also suggest that there's direct liability here because the defendant, Mr. Branca, ratified the actions of the agent by using threatening language with the appellant thereafter.
I may not agree with you on that, but I just think nobody's thinking about this right.
I just want to clear up one question, because you've referred to a Merrimack College KPMG case.
Yes.
I don't see that case either in the brief or in the table of contents. And what I see is an MCAD case involving the Merrimack Valley Transportation, but that seems to be very different from what you're describing.
I do have it in my brief, but I did, and it is, I noticed.
I did a word search using both KPMG and Merrimack, and the only thing I came up with was the Merrimack Valley, not Merrimack College.
I apologize. Oh, there it is, page 22.
Page 22 of your brief.
Of my reply brief.
Of your reply brief.
So if I could just continue this, because I think there's a lot of arms and legs to this problem. Assume with me, as I'm sure you'll be comfortable doing, that you've alleged enough for a violation of the employer under 27298. Does the same issue hold through the rest of your claims? Or do we have to worry, this is basically the question that Judge Neyman was asking earlier, do we have to worry about respondeat superior liability in a different way when we start talking about Chapter 93A, when we start talking about the Massachusetts Civil Rights Act, intentional infliction of emotional distress? Aren't the issues slightly different as we get down the line?
They are. So to Judge Neyman's point about whether the scope of employment analysis is the same, respondeat superior has been utilized repeatedly in the employment context in Massachusetts and not very often in the third-party agency public accommodation context. It's our position that, in fact, and let me clarify the record, we believe that we have liability in both the respondeat superior and in apparent authority. We believe we have vicarious liability and direct liability, and I can go through each of those. The scope of employment and whether or not the agent was acting within the scope of employment. She was working in the time and scope, authorized time and scope limitations. She was hired to perform a specific job, cooking and serving sandwiches, which she was doing at the time she issued the racial epithet, and she was motivated, at least in part, by the purpose to serve the employer. And
How so?
Because she is serving an individual.
Okay,
she is cooking.
At least in the Berry case, they cite to the Levi case, 121 Mass 501, with respect to this element, and say the test of the liability of the master, and this is in the context of prong 3, is that the act of the servant is done in the course of doing the master's work, you meet that, and for the purpose of accomplishing it. That, to me, that strikes me, that second part is a tougher road.
Well, a couple of things. One, that it is our position that it is not an independent course of conduct. An independent course of conduct would take the liability outside, potentially, of the scope of employment. She's not entering into an independent course of conduct. Barry entered into an independent course of conduct. He was not hired to run people over. He was hired to be a firearms.
Well, what about the racial epithet?
Well, while the employee one was not hired to issue racial epithets against the constituents, she was in the process of serving him, which is what was her employment job function. That was something she was furthering.
Actually, the racial epithet, as I understand the allegations, occurred after the serving had taken place, serving in quotes.
She's throwing it at him, and they get into an altercation in which
And then she says, right? And the racial epithet, is that critical to your Mass Civil Rights Act claim?
Well, so the Mass Civil Rights claim has two prongs in this case. Civil rights violations were from the racial epithet which was issued, which under August and Jones say that a single epithet is sufficient and intimidating enough to raise a claim for relief. But also in citing or aiding and abetting that Defendant Branca perpetrated when he spoke with the appellant 11 days after it had happened and told him not to worry about being a snitch and just point out the perpetrator and don't worry about the street code. I mean, from the perspective of the appellant, he thought that was racially motivated. He was intimidated by it. And again, that would apply.
Okay, let's take that one out, okay? Let's talk about what happened at the restaurant from the purposes of a Mass Civil Rights Act claim. Do you have a viable Mass Civil Rights Act claim without the racial epithet?
I think it's a weaker claim, but I do think it is a claim. He was treated differently in a place
How
of
was
public accommodation.
how was that accomplished? So you say, yes, there was a violation of the public accommodations law. How is that accomplished with threats, intimidation, or coercion if you take the racial epithet out of the...
I think if you take the racial epithet out of it, it is probably a less viable claim. I'm not saying it's not viable. What I'm saying is that if an individual under Section 98 of 272, if an individual is treated differently in a place of public accommodation based on their race, is that threatening or intimidating? She looked up, the employee one looked up at the appellant and said, he can wait, and made him wait a full 15 minutes to get his...
And that's threats, intimidation, or coercion for purposes of the Mass Civil Rights Act?
I think it reaches the plausibility threshold of a prima facie case. The question is...
The reason I'm questioning you on this is because it seems to me that the viability of your claim against the employer may turn on the racial epithet. And if it does, then it seems to me you have an issue with respect to whether or not that plausibly was within the scope of her employment to throw that out after she'd completed her role as providing food to this person.
So I think, Your Honor, with all due respect, I think there's a misunderstanding generally and a narrowness of the scope of employment. The fact that she was acting as an agent for the employer, the fact that she was behind the counter and serving, and whether or not it was seconds after she threw the sandwich at him or as a result, it should not make a difference. It was not an independent course of conduct. It was an escalation, which the restatement has said if an individual acts tortiously while performing their duties, which she was, and she escalates as a result of performing her duties.
Of her duties. That's helpful. Thank you. Thank you.
I just have one more question. With respect to your 93A claim, I did not see a demand letter filed. Is that obligation not required in this context?
No, I do believe we provided a demand letter. It may not be part of the record. That was my oversight. But there was one. I don't think there's going to be any dispute about that.
I'll ask you, brother. Okay,
Yes.
Thank you.
So from the...
Oh, I'm sorry. We're well over time.
Are we?
But,
I'm sorry.
Judge Englander has one more question.
Totally different topic. Do you think that you have sufficient allegations in your complaint to get to the other 7 corporate defendants who you do not allege specifically were the owner of this particular Dunkin' Donuts?
Yes, Your Honor, I do. I would assert that the issue of the single employer liability is not something that necessarily has to be before the
The
court.
words single employer liability are not in the complaint.
No, I simply named the defendant. I named each of the defendants and noted that they have common ownership, interrelation of operations, common management, and common labor. Now,
I don't recall those being in the complaint. I recall those being in your opposition to the motion to dismiss, but I'll take a look.
Right.
Okay.
Thank you.
Thank you.
The appellees?
Good morning, members of the panel. May it please the court, John Willis for the defendants' appellees, Branded Management Group et al. The court should affirm the trial court's decision because the trial court correctly found that there was no vicarious liability where, as alleged in the complaint and accepting the allegations of the complaint as true, Ms. Cook was not acting in the scope of her employment. I want to address one of the last points that Justice Englander brought up, and that is what is absent from the complaint. I'm not going to go through the allegations in the complaint now, but even though the plaintiff brought 7 claims against 10 defendants, there isn't an allegation that any corporation employed the cook or that any individual employed the cook.
Okay, so let's leave that. I think that's a different set of issues that we should address in oral argument. And let's go back to the fundamental question of whether they've stated a claim against whoever the owner was of this place of public accommodation. Doesn't 272 Section 98 impose a duty on the owner not to discriminate on the basis of race?
Well, Your Honor, the statute itself says whoever engages in these prohibited acts. The MCAD, in interpreting Section 98, has not determined that there is automatic strict liability where an individual engages in prohibited conduct and therefore the employer is immediately liable because that person happened to be satisfying point 2.
What is the test that we should apply in analyzing that question? I mean, is it, it's really acting as agent or representative, isn't it?
Well, Your Honor, and you're referring specifically to the Chapter 272 claim?
Yeah.
So we believe that the court applied the proper test, which is looking at it from the perspective of a tort. This mirrors how the federal district court had addressed the issue in the Brooks versus Martha's Vineyard Transit Authority case. Chapter 272, as the federal court noted, was originally described as an action in tort, and it has been interpreted using tort principles. So if we look
the injury may be based in tort, but the relationship that would extend liability from the actor to the entity on behalf of which he acts or she acts seems to me to be based in contract principles. No?
Well, I don't think it's necessarily based in contract principles, Your Honor. The MCAD has addressed this by looking at the acts of the individual. They've incorporated some agency principles, some agency theory, but they've also indicated, and this is in the Sahir case, this is one of the plaintiff's principal cases, a hearing officer deciding the Sahir case distinguished the facts of the Sahir case from a case out of this court, Timpson versus, I believe it was Safety Insurance Company. And in the Timpson case, we had a situation where the Patriots football player who was involved was not within the scope of his employment, even though he was within the workplace, he was where he was supposed to be, he was on company time.
He was engaged in an action of sexual harassment. That doesn't have much to do with playing football.
Well,
he or she was engaged in providing food at a place of public accommodation.
So, Your Honor, if we look to the Timpson case, as the hearing officer from the MCA did in the Sahir case, Sahir was distinguished from those circumstances because that individual, Timpson, was not in the scope of his employment. But the fact that the MCAD would look to Timpson in the first place...
Well, but the MCAD, with all due respect, is not really the preeminent authority on this question. We certainly respect what they have to say, but they are not an appellate court.
I agree, Your Honor, but I do think that it's instructive that the hearing officer looked to see whether this person was acting in the scope of their employment. Because if we apply an agency test, or if we apply a tort-based test under traditional tort principles and of respondeat superior, either way, this individual is not acting in the scope of her employment. We have
Toward responding superior and agency really could lead to quite different analyses on different facts. And we're not going to worry about what happened with the Patriots player in Timpson. We're going to worry about what happened with the individual who was assaulted while asking for a food order.
I'm still having difficulty with your first answer, and the jury's out on exactly what the statute says, because unfortunately we don't have it directly behind us. But I read 272, Section 98 as imposing a duty on the place of public accommodation and not on just the individual employees within it. The place of public accommodation cannot, it can't, I mean, this goes back to the 60s, right? And some of this is related to that.
Well, Your Honor, under that interpretation, anytime we had an individual who was within the place of public accommodation, employed by the place of public accommodation, even if they acted in a manner that was entirely contradictory to their employer's interests.
If they didn't provide the public accommodation and they didn't provide it on the basis of race, they're liable. That's the way I read the statute. Now I'm going to read it and see if I'm wrong. But, you know, no one said this, but it just seems to me that that's what this is about. You go into a place of public accommodation, and they cannot discriminate against you on the basis of race. And they certainly can't say, they can only act through their employees. They certainly, it seems to me, what you're saying is, I represent a place of public accommodation. It is alleged that my place of public accommodation did not provide food, and they did it because they were discriminating on the basis of race, but we're not liable because our employee did it. I'm astonished at the notion, just sort of sitting there, you know, why? I'll read the statute.
Your Honor, I think the relevant and salient point here is that at a certain point, an employer can only have so much control over their employees. And agency theory, if we apply agency theory, the liability to the employer is, if it's going to flow through agency principles, there has to be some sort of control. And if
yes,
an individual...
but the question of whether the way that the motion judge approached this. Let me just start. You know, you went to one end of the spectrum. I'm going to go to what I think may be another extreme end, and that is the analysis the motion judge applied, which seems to suggest that when an employee does something that that is misbehaving, then by definition they are outside of the expectations of the employer. And that is too narrow a reading, it seems to me, as well. These areas are fact-intensive, they're highly specific, but that's one of the reasons why we have to go a little bit farther than the motion to dismiss, isn't it?
Respectfully, Your Honor, no. First, there were a number of facts pled in the complaint that detail what was alleged to have happened in the restaurant. There's about a dozen.
But this is not a situation, for example, where the employee engages in criminal conduct wholly unrelated to the services for which they are employed.
Well, Your Honor, I would say that the conduct alleged here was wholly unrelated for the purposes this person
Well,
was
let's
employed.
take, just as one example, the presentation of the food order. There is an appropriate way to do that, but throwing the order at the customer is quite literally delivering the food to the customer. We're into a fairly nuanced assessment of and obviously the employer would not wish that to be the case, but then we get back into the question of if we're not going to define away anything that the employee does that is not high performance of the employer's objectives, which can't be the test.
No, Your Honor, I think we have to look at the entirety of the circumstances. Right. That's what the Berry Court has instructed from the SJC in looking at, again, I'm returning to the issue of respondeat superior liability, but I think that the Berry case is very instructive and it's applicable here. And the court in the Berry case looked at the entirety of the circumstances, looked at what this person was supposed to be doing, the police officer in that case, and then what he was alleged to have done that gave rise to the claim. And when you look at the greater context Here, we have a situation where this person was allegedly refusing to do any of their duties, refusing to listen or comply with the coworker's request to prepare orders, only to show another coworker something on her phone for at least 15 minutes total, as alleged in the complaint. And then when she did finally
What do you
act,
take from that? What do you draw from those facts? That she's not operating within the scope of her employment?
Exactly, Your Honor, that she had no
What about the other
employment-based purpose.
employees? Are they acting within the scope of their employment by not correcting her and getting the food to the person who's ordered it?
It appears, as alleged, Your Honor, that they were trying to do their job.
Trying to
and
get
have
her
the
to do it. Why didn't they just do it themselves? Why did they leave this person there for 15 minutes?
I can't
And
say.
isn't your client responsible for that? Because it's a place of public accommodation.
Let me put the question a slightly different way. While we're in the middle of this context-specific, if you could draw out for me what, in your view, would constitute an example of actionable conduct by an employee that would properly be charged to the employer in a place of public accommodation within the scope of racially discriminatory conduct.
Of course, Your Honor. The simple example comes from the Brooks versus Martha's Vineyard Transit Authority case.
Please speak up.
In Brooks, we had an individual who was charged with operating a shuttle bus. In the course of operating the shuttle bus that's got passengers, he's on the route where he's supposed to be, he refuses to pick up the plaintiff in that case. And then later, there was an exchange of words.
Let me just pause for a moment there. So, refusing to pick up a passenger is distinguishable from refusing to fill an order in what respect? Material to the relationship between the employer and the employee.
Well, the difference, the material difference between the two sets of facts is that in Brooks, we had an individual who was doing what they were supposed to do, namely operating a shuttle bus. Here, we had an employee who was allegedly supposed to be preparing orders and doing.
She was preparing. Well, she was on the job. She was in uniform behind the counter. Driving the shuttle bus is one part of the job. Opening the door for patrons who wish to ride the bus is another part of the job.
And he didn't do that part.
And so, I guess I'm struggling a little bit to understand the difference between refusing to open the door and refusing to cook the food.
Your Honor, I think that the facts as alleged show that this individual was not in any way, in terms of the greater scope of the acts alleged, was not in any way furthering an employer's interests in terms of.
How do we know that?
Well, it's quite clear, Your Honor, that she was ignoring her duties, and she was alleged to be ignoring her.
She was not serving this particular customer. How do we know that that wasn't furthering the employer's interests?
Well, Your Honor, she was alleged to not have prepared any orders because, as alleged in the complaint, she was showing someone else on
my point
her
is,
phone.
maybe it's too subtle, but my point is this. It's a motion to dismiss. There are, and I'm not saying this at all about your client, but there are situations you can read about in the papers where particular institutions make the exact decision that is alleged that your client's employee made, where the institution is supporting that kind of decision. Now, I'm not saying that about your client at all. I'm just saying it's a motion to dismiss. So when you, and when the judge say, this is clearly not in the interests of the employer, I'm stuck with, well, how do I know that? Because we are on a motion to dismiss.
Well, Your Honor, I think it's clear looking at the allegations as pled and accepting them as true, what this person was alleged to have done, putting aside the alleged use of a racist epithet, what she is alleged to have done is antithetical to any employer interest, to refuse to do any duties, to refuse to do any job duties or respond to coworkers' requests.
That's just not consistent with history. That's not consistent with history. It's a nice place that we would all hope that we would be at, but on a motion to dismiss? I have other questions. I don't.
So, I mean, you could have let's just say an owner of a lunch counter that directs the staff not to serve persons of color. Let's imagine that as a hypothetical.
I think, Your Honor, that would probably be a clear violation of Chapter 272.
Yes, but we are on a motion to dismiss. We don't know whether those instructions were in existence here, do we?
It's not pled, Your Honor. That's not pled in the complaint. It's
Well,
nowhere-
I don't know that they have any basis to plead it. What they have is a basis to plead that they were denied service on the basis of race, and so they've made that allegation. To dismiss that claim as to the employer,
Based on not being consistent with the employer's objectives without any basis in the record.
on a motion to dismiss? Can we, with the indulgence of...
We've gone over before, why not
Well,
continue?
he started with, to talk about the last issue, which is the issue of the other 7 corporate defendants.
Well, before you get there, then, because I need to ask 2 quick questions. Number 1, do you concede that the 93A demand letter was properly served in this case, and that's not at issue?
Your Honor, I can't definitively say one way or another. I frankly do not recall, and I know that it's not in the record.
Okay.
You're not making an issue.
But you didn't raise an argument as to it, so.
I don't believe that was one of the arguments we made at the motion to dismiss stage.
Okay. My next question before you go on to Justice Englander's questions about the 7 corporate defendants, 7 additional corporate defendants is, you've already addressed this, but in terms of the 3rd prong of the Wang test, whether the tortious conduct was motivated at least in part by a purpose to serve the employer, what is your best authority for the proposition that the Wang Labs test applies to 272-98?
Well, Your Honor, it's not definitively addressed in any case of which I'm aware. The MCAD, as I indicated earlier, has looked to this court's decision in the Timpson case. I don't necessarily think the Timpson case is the best illustration in terms of its applicability to these facts. It is fairly square here. I think that the Berry case is the most apt comparison. But I'm not aware of any case where Chapter 272 has been applied with this level of detail.
That's helpful. Thank you.
So the 7 corporate defendants.
Yes, Your Honor.
Your argument is there's no allegation as to the other 7 that they had anything to do with this. Now, you make that argument in a motion to dismiss. The response is, hey, they've now provided a response in the MCAD, and they're all interrelated as a single entity. Why isn't that a sufficient response?
Well, a few points, Your Honor. First, the fact that a position statement was filed with the MCAD, for one, it's not relevant on this motion to dismiss. The position statement was not attached to the complaint. It was not an exhibit, and that is not a public record. The plaintiff has cited the Larrabee case out of this court, the appeals court, for the proposition that...
Are you telling me it's not true? It's not accurate?
No, Your Honor, the statements in the position statement are accurate.
Is it what you're really saying is technically they haven't alleged it, although they put a sufficient response in their opposition, they ought to amend their complaint to make these allegations?
Well, Your Honor, I don't make any representation as to what the plaintiff should or shouldn't do, but what is not in the complaint is clear. What is alleged in the complaint is a bare bones allegation that, for example...
No doubt, because that's all they can find out from the public record before they have an opportunity to conduct discovery and find out how these 8 corporations are related.
Your Honor, I can't speak for plaintiff's motivations in crafting the pleading.
If they amended their complaint and put into their complaint what they put in their opposition to the motion to dismiss, would you still have a motion to dismiss?
I believe so, Your Honor.
What would the argument be?
For which claim specifically?
As to these 7 defendants that you want to see dismissed, who are not alleged to be the owners of the actual Dunkin' Donuts, what would your argument be? If, I read their opposition this morning, if they took what's in their opposition, they alleged it in the complaint, it's entirely based on the representations that I understand you folks made in response to the MCAD. If they made those allegations, would the claims against those 7 defendants still be dismissible, and why?
It would still be dismissible. Dismissal would have been appropriate in those circumstances because the single integrated enterprise theory For one, it comes from Title VII cases, specifically the Torres-Negron case out of the First Circuit. I don't believe that the First Circuit has formally adopted the single integrated enterprise theory. I'm not certain that it is the law of the First Circuit, but it is applicable in Title VII cases where we have an employer and an employee claim, not a claim of this sort involving, as my sister counsel has called, a third party. That's the first point. The second point is that—
Why wouldn't, so as I understand it, one of these defendants is actually the employer according to your own representations. So we have one of the defendants that is the owner, another is the employer. Why wouldn't we allow the claims to go forward at least until we find out who the proper defendants are and who has the money? Right? Isn't that what this comes down to?
Well, Your Honor,
it's a claim in the nature of tort.
I'm not aware of a case, and I'm fairly certain that plaintiff doesn't cite a case that provides that just by mere virtue of an ownership interest, an individual or a corporation or any entity could be liable under the circumstances alleged in the complaint. If we follow that logic to its conclusion, let's say this had happened in a place where the owner was publicly traded, and I own shares of that corporation. Under plaintiff's theory, I, as a shareholder, could be liable for the acts of an employee. And I don't think any case goes that far. And that's what the plaintiff has tried to advance here in this case.
That's good. All right. We're well over time. Thank you. Very interesting case. That concludes the argument in this case, and with it, the arguments in the last of our cases in this session. We are adjourned.
All right, please.